IT has confirmed that we are video streaming. Good morning. We are now on the record and video streaming. I call the evidentiary hearing to order in the matters of docket numbers 22 CONS 3124 CPEN, 22 CONS 3150 CPEN, and 22 CONS 3215 CPEN, and the failure of Ace Energy LLC to comply with K.A.R. 82-3-111 at 45 Wells in Crawford and Neosho Counties, Kansas. I'm Susan Duffy. I'm serving as chair of the Kansas Corporation Commission and will be serving as presiding officer for this hearing. And I am joined by my fellow commissioners, Dwight Keene and Andrew French. Good morning, everyone. First, I will start with the entries of appearance and commission staff.
Tristan Kimbrell on behalf of commission staff and the public generally.
Very good. And Ace Energy.
Yeah, thank you, Chair Duffy. This is John Schlatter of the Morris Lang Law Firm on behalf of Ace Energy, and I believe I have Mr. David Bedeau as well present today.
Very good. Thank you. Does staff have a recommendation regarding notice of this hearing?
Yes, notice of this hearing was contained in the presiding officer order setting this evidentiary hearing filed on February 16th, 2023. The order was properly served on all parties. Staff further notes that all parties are in attendance today. Based on these facts, staff recommends the commission find that notice is proper and that the commission has jurisdiction to hear this matter at this place and time.
Very good. Are there any objections to notice? Hearing none, and based on staff's recommendation, I find that notice is proper and the commission has jurisdiction over this proceeding at this time and place. Okay, we're going to move on to a few preliminary matters and then discuss procedure during the hearing. First, we are conducting this hearing over Zoom, and sometimes things go a little wonky. If any party encounters a technical issue, just please ask to go off the record. Then we can resolve the technical issue and go back on the record. Second, witnesses are asked to keep their microphones off or muted when you're not testifying. And please, everyone, mute your cell phones, phones in the office, and other electronic devices. Third, so that parties are aware, if the commission needs to consult among ourselves, we'll go off the record and the commission will enter what we call a Zoom breakout room, discuss what we need to, then we'll return from the breakout room and go back on the record. Finally, as we are doing this by Zoom, please be careful to identify exactly what you're referring to when discussing pre-filed testimony and filings. We have copies of everything on hand. We should be able to identify it very quickly. Plus, I will add that our counsel, John Myers, is extremely adept at bringing things up and sharing them on the screen. Okay, do parties have any preliminary matters to take up at this time? Okay, hearing none. In regard to
Chair Duffy, I actually do have one thing.
Oh, okay, yes.
It's a technical thing and a technical failure on my part, which we'll probably get to see a few of those here later on today. But we had filed exhibits with Mr. Frieden's testimony originally. Those were pulled from the KGS website. They're just the TA applications that were submitted pursuant to the settlement agreement. The way they were merged, apparently there was something called metadata behind them. And when they were merged, it washed what I was looking at and changed it to something that I'd never seen before. And I didn't notice it until yesterday. And so we filed corrected exhibits that have the exhibits that I saw on my computer when we prepared and filed those. And I just want to make sure everybody has those and that the other ones are, frankly, I don't know what they are, but they're not what we intended to file, and you should have the correct exhibits today.
Very good. I'm going to turn to John Myers. John, I do think we received the corrected versions later in the afternoon. Is that correct?
Yes, you did receive the corrected exhibits. What you have not received, Mr. Schlatter sent, well, you also received a potential ACE cross exhibit
Right.
this morning. What you have not received is Mr. Schlatter emailed a couple more. I don't know if they're filings or potential exhibits, but filings F4 and F5. Commissioners, you do not have those. Mr. Schlatter, if you'd like me to email them to the commissioners now, I can, or we can deal with it if the issue arises.
Yeah, F4 is just what you received yesterday marked. I didn't mark it. And so now it's been marked as F4, and F5 is another cross exhibit, sort of the same material.
Okay, commissioners, what I will do, if it's quite all right with you, is I will email those two things to you now, and in case they arise.
Okay, all right. Thank you, Mr. Schlatter, and for clarifying that. It was my understanding that one exhibit was just the naming of it, and the other one, then we have something new. Okay, very good. Thank you, John. Okay, now we'll move on to preliminary matters and discuss some procedure during the hearing. Oh, I guess we did do that. All right, procedure. Typically, parties are allowed to make opening statements. After opening statements, we'll examination of witnesses. After direct examination of each witness, there is an opportunity for cross-examination, commissioner questions, and redirect. Any further examination will be at the discretion of the commission. Following witness examination, parties typically make closing statements and arrange for the filing of post-hearing briefs if necessary, and then we will conclude the hearing. Okay, so let's go to opening statements. And I believe Tristan Kimbrell, you are to give the statement for staff.
Yes.
Okay, please proceed.
Thank you. Commissioners, oil and gas dockets tend to be fairly complex, but this one is extremely simple. All it requires is the ability to count to 10. Ace Energy signed a settlement agreement drafted by its counsel in May of last year. In that settlement agreement, Ace Energy agreed to bring 10 wells into compliance with commission regulations by December 31st, 2022. As of today, only 6 wells have been brought into compliance. More importantly, the settlement agreement states that the first wells to be brought into compliance are the wells on the Thornton lease. And these wells are to be brought into compliance first because they're injection wells. And as you know, injection wells out of compliance with the regulations are most likely to lead to pollution of usable waters. To date, Ace Energy has brought only 5 of the wells on the Thornton lease into compliance, with the other 4 wells still out of compliance, still posing a threat to usable waters. Now, Ace Energy's counsel is going to try and do his best to make it difficult for you to count to 10. He'll try to make a big deal about staff revoking the TA status for several operators' wells. He'll claim that this was unfair and a burden on Ace Energy. We intend to show that the reason the TA status for those wells was revoked was because Mr. Frieden filed false information with the commission. Staff initially approved the TA status for several of those wells because it relied on that false information. But fortunately, staff discovered that there had been false information filed with the commission and subsequently revoked the TA status for those wells. And it should be noted that staff discovered the false information and revoked the TA status for those wells within the time frame required by the settlement agreement. If Ace Energy was burdened by this, it was its own fault for trying to deceive staff and the commission. Commissioners, once you begin your count and realize that Ace Energy has only brought 6 wells in compliance, not the 10 that's required to do, the next question is, what should you do about it? The settlement agreement states that if Ace Energy misses a deadline, its license shall be suspended and its license shall remain suspended until all the wells in the agreement have been brought into compliance. Ace Energy has missed the deadline. Ace Energy's license should be suspended, and Ace Energy's license should remain suspended until all 45 wells in the settlement agreement are brought to compliance. Thank you.
Thank you, Mr. Kimbrell. We'll move to Jonathan Schlatter.
Thank you, Chair Duffy. I think it's important to recognize 2 things that are substantively important about today's hearing. The first is the posture of this action or evidentiary hearing. it's not a penalty order. It's not an application as the commissions usually would take up. It's a motion to suspend Ace Energy's license filed by staff. It's, put another way, it's a motion to put Ace Energy out of business. That's what we're talking about. It's a motion. It's the second time in 3 months staff has sought to put Ace Energy out of business. The last time it tried to do this, it lost. The commission found that it did bring 5 wells in compliance. Well, here we are again today. Second thing is, obviously, putting somebody out of business is a very serious matter. And that's why the staff has the burden of proof today. It needs to prove the things that it just said in its opening statement. I'm going to say that again. Staff has to prove those things. Now, I understand, and I'm a Johnny come lately of many, there's many Johns in this room. I'm Johnny come lately in this docket, and I'm trying to get up to speed as to what's going on. And I think I've got a decent grasp of it. But there's 45 wells at issue in this matter that is subject of this settlement agreement. I looked at staff's testimony and I spent some time trying to figure out which wells are compliant, which wells aren't. And I gave up. I can't figure it out. It is a mess. And to say that we can't count to 10 is absurd on what's filed. And it's as absurd as saying that there's false information provided, because there's nothing in the record that shows any false information was ever provided. I mean, direct is over. We're at cross-examine right now. That opportunity to put on that evidence, it ended, and it ended a while ago. But all I see is a bunch of anecdotal evidence, acute legal arguments as to why certain wells aren't compliant. I don't see any effort to work with operator to actually facilitate compliance and to achieve these objectives, whatever we are, because I don't know what they are. I can't figure it out. But I started fresh. I pulled the pleadings. I figured out what the 45 wells were. I went down and looked and saw what was filed, what we have of record. I worked with Mr. Frieden to determine where we're at here. And I concluded that there are 3 wells of the 45 that still need to be brought in compliance. And those 3 wells are the Gale Mullen B40, the Underwood 6 089, and the Underwood 6 089. And I know that I just said the same well twice. Well, one of those 089s has a space between it, and it also has a different API number, so it's actually a different well. So there are 2 089s. Both of them need to be brought into compliance. So does the Gale Mullen B40. Everything else is compliant or was compliant, or there's a pretty good case that it should be deemed compliant. And that's what the evidence will actually show today. So I think staff's behavior in administering the settlement agreements created a lot of confusion and controversy. Confusion and controversy is not evidence, and that's not going to sustain a burden of proof. Frankly, I think most of these issues could have been and should have been resolved in the field. These are not really commission matters, and a phone call or an email could have resolved some of these technical violations or disputes. And that's really how this should have been solved, and that's what I'm going to demonstrate today. So, in conclusion, I don't think the evidence is going to carry the day that 10 wells haven't been brought into compliance, because 42 have. And the fact that we don't know which wells are and aren't and can't and aren't and will not be and maybe and arguably aren't, that's not what this motion's about, and the motion should be denied.
Okay, thank you, Mr. Schlatter. We're ready to proceed to the examination of witnesses. As you're aware, we don't have a court reporter, so I'll be swearing you in. Let's start with Mr. Kimbrell. You may call your first witness.
Thank you. Staff calls Ryan Dooling.
Good morning.
Good morning, Mr. Dooling. How are you?
I'm good, Chair. How are you,
Okay.
ma'am?
If you'll raise your right hand, do you swear or affirm that the testimony you shall give today is the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Mr. Dooling, could you please state your full name for the record?
Ryan Dooling,
By whom and in what capacity are you employed?
I'm employed as a compliance officer and environmental compliance regulatory specialist with the Kansas Corporation Commission out of District 3 in Chinook, Kansas.
And what is your work address?
137 East 21st Street, Chinook, Kansas, 66720.
Are you the same Ryan Dooling who caused to be filed in this docket direct testimony consisting of 13 pages and 6 exhibits?
I am.
Was this testimony created by you or at your direction?
Yes, it was.
Now that you're under oath, do you have any corrections to make to that testimony?
I do not.
If I asked you today the same questions contained in your testimony, would your answers be the same?
They would.
Do you swear the answers contained in your pre-filed testimony were and are true to the best of your knowledge?
Yes.
Thank you. At this time, Chair Duffy, I would move for the admission of Ryan Dooling's pre-filed direct testimony and attached exhibits to the formal record.
Okay, any objection? Hearing none, it is so ordered. Thank you. Continue.
Thank you. Chair Duffy, Mr. Dooling did not have an opportunity to submit pre-filed rebuttal testimony. May I ask rebuttal questions at this time?
Okay, very good.
Thank you. Mr. Dooling, in Mr. Frieden's testimony on pages 6 and 7, he indicates that all the wells on the Thornton lease are in compliance with the settlement agreement. What wells needed to be brought into the compliance with the settlement agreement first?
The injection wells on the Thornton lease, there was 9 in E.A.R. wells on the Thornton lease that needed to be brought into compliance first.
And how many of those wells have been brought to compliance?
We've counted 5 that has been brought into compliance. However, 4 were actually brought into compliance the first quarter. But the commission decided that the 5th well needed to be counted as in compliance also. So 5 wells on the Thornton.
Okay. Mr. Myers, could we bring up exhibit RD6? So that's Ryan Dooling's exhibit 6, page 4.
Yes, one moment.
May I ask a question about
Please.
this? This is already in pre-filed testimony. Why are we talking about this?
This is rebuttal. Mr.
Rebuttal
Frieden
is
claimed in
not
his testimony.
Direct testimony. I mean, this is in your direct testimony. What are we doing?
Mr. Frieden said in his direct testimony that these wells were in compliance. This is Mr. Dooling's rebuttal.
In Mr. Dooling's direct testimony, it says they are not in compliance. The dispute is well documented.
Mr. Kimbrell, do you have a response?
That is Mr. Dooling's, that Mr. Frieden's testimony claims that these wells are in compliance. Mr. Dooling has an opportunity, should have an opportunity to rebut that by talking specifically about the wells that Mr. Frieden claims are in compliance. That's the intent of this rebuttal, is to talk specifically about these wells.
Okay, I'll allow it. Continue.
Thank you. We could go down to page 4, please, Mr. Myers. All right, Mr. Dooling, can you see that?
Yes, sir.
And what is this, a picture that we're looking at?
That is a picture of a 2 7/8 casing that is open to the surface in the same state the well has been for several years. There's a riser to the right of that well. As you can see, the well is not connected to the injection line, and it's open, not shut in.
All right, let me back up just a little bit. Is this one of the wells that Mr. Frieden claimed in his testimony was returned to service?
I believe so, yes. If he said all of them were in service, and that is not correct.
I'm going to object. That is a mischaracterization of Mr. Frieden's testimony.
All right, let me ask this a different way then, Mr. Dooling.
Written.
When was this picture taken?
This photo was taken on January 3rd of 2023.
On January 3rd, was this well returned to service?
No, sir.
On January 3rd, was this well plugged?
No, sir.
On January 3rd, was this well TA'd?
No, sir.
Thank you. If we could scroll down to page 6, Mr. Myers. And is this also one of the Thornton wells, Mr. Doolin?
Yes, sir.
And when was this picture taken?
January 3rd of 2023.
And what are we looking at in this picture?
This is a 2 7/8 cased well that is shut in with a gate valve.
On January 3rd, was this well returned to service?
No, sir.
On January 3rd, was this well plugged?
No, sir.
On January 3rd, was this well TA'd?
No, sir.
Thank you. If we could go down to page 8. And is this also one of the Thornton wells?
Yes, sir, it is.
And when was this picture taken?
January 3rd, 2023.
And what are we looking at in this picture?
This is looks like a 2-inch well that is shut in with a gate valve.
On January 3rd, was this well returned to service?
No, sir.
On January 3rd, was this well plugged?
No.
On January 3rd, was this well TA'd?
No, sir.
Thank you. And then Mr. Mars, if we could go down to page 10. Is this the 4th well on the Thornton lease?
Yes, it is.
And when was this picture taken?
January 3rd, 2023.
January 3rd, was this well plugged?
No, sir.
On January 3rd, was this well returned to service?
No, sir.
On January 3rd, was this well TA'd?
No, sir.
Thank you. We can take down the exhibit. In Mr. Frieden's testimony on pages 4 and 5, he states that these 4 wells on the Thornton lease, that staff approved them as being in compliance with the settlement agreement, then unapproved them. Is this correct?
No, sir, that is not.
Is it possible that while they were out in the field, members of District 3 staff may have told Mr. Frieden or one of his pumpers that the wells were in compliance?
No, sir, it's not. Staff only went to the 5 wells in the first.
Jack, that is abject hearsay.
And Mr. Kimbrell, can you restate or your point here for the witness, please?
Mr. Dooling, are you aware of any agents of the district staff who told Mr. Frieden that the wells were in service or that the wells had been in compliance?
No, sir.
And it calls for speculation.
I'll allow it. We understand. I believe that it is based on, are you aware? So I will allow that. Continue on, Mr. Kimbrell.
Thank you. Mr. Myers, if we could bring up exhibit RD-1.
One moment.
Thank you. Mr. Dooling, is this the letter that you sent on July 29th, 2022 to Ace Energy revoking the TA status for 26 wells?
Yes, it is.
In Mr. Frieden's testimony, he states that he doesn't understand why this happened. Can you please explain why you did this?
Yes. Staff reviewed the TAs when they first come in and were approved and sent on to administrative staff before I was able to review them. After reviewing the TA applications, I found many discrepancies in the applications. 20 of the 26 wells had been TA'd and shut in over 10-year time frame, which the operator would have had to apply for a exception to the 10-year rule. There was also 3 wells on the Thornton lease. 2 wells were open, and remind that there's other, this is not the only reason they were denied, but this is the reason that was in the letter. 2 Two of the wells were open to the surface, not shut in, could cause pollution to fresh and usable water. One of the Thornton wells, the construction that the application showed did not coincide with the way the well was constructed. There was also 3 other wells listed as number 4 on the number 4 there that were staff found that were plumbed for the use of enhanced oil recovery wells that were unauthorized. The TA applications were listed as oil wells, which is what they were supposed to be. But they had also been shut in for over 10 years on other applications. So that is the reason those 26 wells were revoked due to falsification of the applications.
Thank you. So on the first page there, where it says wells that exceed 10-year shut-in dates, the first well is the Gale Mullen E43, and the second is the Gale Mullen F41. Am I reading that correctly?
That is correct.
Okay, thank you. On pages 3 and 4, Mr. Freed's testimony, he states that for the wells on this list in this letter, the TA applications he filed indicated a shut-in date of less than 10 years. Mr. Miles, if we could go to the staff's exhibits with the file labeled Gale Mullen E43, approved TA 3-2-2020.
One moment. Mr. Kimbrell, I'm going to have a bit of difficulty pulling that up right away. I have all of those files merged into one file here. Which well did you say it was?
The Gale Mullen E43.
Okay.
If it would be easier, I
Here
could
we go.
share my.
There it is.
No, I can control F on the file, and I believe I found it for you. Is this what you're looking for?
Yes, it is.
Okay.
Mr. Julian, could you explain what this is?
Yes, this is a TA application that the operator submitted back in 2020 for the Gale Mullen E43. This TA application was approved by staff on March the 2nd of 2020.
And what is the shut-in date indicated for the well?
12/1 of 2010.
And did Ace Energy put in that shut-in date? Or
Yes.
Thank you.
No,
Sorry, it was Ace Energy that put in the shut-in date.
yes, this information was provided by the operator.
Thank you. Mr. Myers, if we could go to the Gale Mullen number 43 denied TA.
Is this what you're looking for? No, it can't be. It says approved. Hold on.
Yeah. You might need to go up.
I apologize. I wasn't anticipating needing to find them in this manner. If you give me just one moment, I can pull up the email attachment and grab it that way.
That's fine, John.
Hold on. It's nothing like trying to find something while everyone's waiting for you. Which It's the E43 is what we're talking about here.
E43 denied TA
Denied TA,
6-30.
okay. I have found the document. Give me just one moment to share. Here you are.
Thank you. Mr. Dillon, could you please explain what this is?
Yes, this is a CP 111 application for the Gail Mullen E43 that was submitted in the year 2021.
And was this approved or denied?
This application was denied on June 30th of 2021.
And why was it denied?
It was denied because previous CP 111s that had been approved showed a shut-in date of 12/1 of 2010. And then this year, since the date would have been past the 10 years, it conveniently moved to 1/1 of 2021.
Thank you. And then Mr. Myers, could we please pull up the Gail Mullen E43 approved TA 7-12?
One moment. I believe this is what you're looking for.
Yes. Mr. Dillon, could you please explain what this is?
Yes, this is a CP1 application that was filed for the Gail Mullen E43 in July of 2022.
So was this filed after the settlement agreement?
This was filed for the settlement agreement. The operator had I take that back. This came in before July 1st deadline. The operator did get all the 45 TA applications submitted to district staff. But this was submitted to district staff for the settlement agreement.
Thank you. And what is the shut-in date on the TA application?
On this application, it shows January 1st of 2019.
And did Ace Energy enter that date in there?
Yeah, yes, they did.
Do you believe that this well was shut in 2019?
No, I do not. I believe the original date that's been submitted for years is accurate.
Do you believe that Ace Energy provided false information to the commission on this TA application?
Yes, I do.
Thank you. Mr. Myers, if we could please pull up the Gail Mullen number F41 approved TA.
One moment. Mr. Kimbrell, I see two marked that way. One's dated July 12th, the other July 14th.
Yes, I apologize. The one that's 714-2020.
Very well. Hold on.
Thank you. Mr. Dooling, what are we looking at here?
This is a CP1 application for the Gail Mullen F41 that was submitted in the year 2020.
And what is the shut-in date on the TA application?
The shut-in date is 12/1 of 2010.
Thank you. Mr. Myers, if we could please go to the Gail Mullen F41 denied TA.
I believe this is what you're looking for.
Thank you. Mr. Dooling, what is this?
The CP1 application for the Gail Mullen F41 that was submitted in the year 2021.
And what is the shut-in date on it?
The shut-in date is 12/1 of 2010.
Thank you. And then Mr. Myers, could we please go to the Gail Mullen F41 approved TA 7/12/2020?
Is that 7/12/2022?
Sorry, yes, 2022.
One moment. Here you are.
And what is this, Mr. Dooling?
This is a CP1 application for the Gail Mullen F41 that was submitted for the year 2022.
And was this submitted to comply with this compliance agreement?
That is correct.
And what is the shut-in date on it?
The shut-in date is 12/1/2013.
Do you believe that the shut-in date for this well was 2013?
No, sir.
Why not?
Previous applications for several years show that the shut-in date is 2010. These wells have not been equipped or produced for several years. So I believe the only reason the date was changed was so it would fall within the 10-year time frame to be TA-able.
Thank you. And these two wells that we just went through, were these the wells that you revoked as
These
part of
were
that letter?
Yes, it was.
Thank you. Chair Duffy, there are 21 other wells that I could ask Mr. Dooling to go through. His testimony would be very similar for each one. If you'd like, I could go through each one of those wells with Mr. Dooling, or if you prefer, I could ask Mr. Dooling to kind of provide an overview and that the commission take administrative notice of the rest of the documents for these wells.
I would prefer that we take administrative notice. Mr. Dooling, if you do want to provide an overall comment, that would be fine. I think those are exhibits, correct, in the filing. So go ahead, Mr. Dooling. We'll accept those.
Sorry.
Go ahead.
Of the 26 wells that were revoked within the time frame provided in the settlement agreement, 23 of those wells would have fell in the same categories of being shut in for more than 10 years. The information provided by the operator is clearly not correct, and that is the reason for revoking them and putting them with the settlement agreement. Staff also believes that probably did the operator a favor, because if not, they would have had 30 days to get all 26 wells into compliance instead of the length of the settlement agreement.
Thank you. Moving on, Mr. Dooling, on page 3 of Mr. Freed's testimony, he states that you did not explain why you'd revoke the TA status for the wells. Other than the letter that you sent, did you have any communication with Anyone from H Energy regarding the revoked TAs?
I had several communications with Mr. Frieden before, during, and even after the settlement agreement wells were noted. I discussed with him why the wells were denied. He did not agree with everything, but he said he knew which wells were revoked.
So when you say he didn't agree with anything, did he actually object to some of these wells having revoked TA status?
None of these wells, no.
Thank you. In Mr. Freed's testimony on page 4, he states that several wells had their TA status revoked for lacking surface control or incorrect casing information. Has Ace Energy remedied the wells that need surface control?
Not as of the last lease inspection, no.
On page 5 of Mr. Freed's testimony, he states that only 4 wells remaining that need CITs. Is this correct?
No, sir, that is not correct.
On pages 6 through 7 of Mr. Freed's testimony, he states that 3 wells were denied TA approval because they were plumbed for injection purposes. He states those wells were on the Thornton lease. Are those wells on the Thornton lease?
No, sir, they're not.
Can you explain why those wells were denied TA status?
Yeah, they were actually denied for multiple reasons. The main reason they were hooked up for enhanced oil recovery injection purposes. They are not authorized or permitted to be putting water down those wells. That was the main reason for the revoked TAs. The other reasons are they have not been produced as oil wells for over 10 years.
Thank you. Has Ace Energy recently submitted any new TA applications?
Yes, I know of, I believe 9 or 10 TAs that were submitted to our district office, I believe on March the 3rd, 2023.
Have you had a chance to review those TA applications?
Briefly.
Do you believe that those TA applications will be approved?
No, sir, they will not.
Why is that?
Again, the information provided on the applications that were submitted are not accurate. The shut-in dates are not the shut-in dates that we've established, the wells being shut in. One other thing to point out is it always asks for a fluid level of each well, which is very important to determine where that static fluid level is in that well. And it's funny, we've done CITs on these wells, which was required by a settlement agreement. But all of these wells have a fluid level of around 197 feet is what he submitted. During the CIT's testing, which was only a couple months previous to that, fluid level ranged from full of fluid to 30 foot. So again, the information supplied by the operator is not correct on the forms.
Thank you. Chair Duffy, I have no further questions and I would tender Mr. Dooling for cross-examination.
Okay, thank you, Mr. Kimbrell.
Chair Duffy,
Yes,
if I may, a housekeeping matter. Mr. Kimbrell asked for administrative notice of various records regarding, I believe it was 26 wells. And I just want to make crystal clear that those records we are discussing are those that Mr. Kimbrell emailed to myself and Mr. Schlatter in an email from Thursday, March 9th at 1:05 p.m. Is that correct, Mr. Kimbrell? Those are the items you wish the commission to take administrative notice of?
Yes, that is correct.
And Chair Duffy, is the commission taking administrative notice of those?
yes, they are. And thank you for clarifying that.
Very good. Thank you, Chair Duffy.
Thank you. All right, Mr. Schlatter, cross-examination, please.
Chair Duffy. I think we got a lot of new ground to cover, Mr. Dooling. We'll get to some of the things you just talked about later. I want to start with the overall purpose of this docket. I believe the premise or the posture is we have a settlement agreement that the commission approved as attachment A to its order approving settlement agreement. I can publish that and will publish that later, but this was approved on May 24th, 2022. It's attachment A is the settlement agreement. I'm going to refer to it as the settlement agreement throughout this testimony. I just want to make sure everybody understands what I'm talking about and that that document's been identified. So fair enough?
Yes, sir.
I'm wondering who from staff is responsible for administering, for lack of a better word, the settlement agreement?
The settlement agreement is not administrated at the district staff level. That is administrated through legal staff.
So legal staff is the proper party to talk about the administration of the settlement agreement?
Are you talking administrated as constructing? Is that better
No, I mean
term?
like deciding which wells are compliant, which wells aren't, keeping track of progress.
I'm sorry, I misunderstood the question. Yes, district staff is responsible for for reviewing the wells on the settlement agreement and the process of bringing them into compliance.
Okay, and you're the proper party then to talk to about the administration of this agreement?
That is correct.
Okay, I just want to make sure I'm talking to the right person, that's all. Were you involved in the negotiation of the terms of this agreement?
No, sir.
Are you generally familiar with its provisions, its obligations, its requirements?
Yes, I've read over it and know the requirements of it.
Who would have been involved in the negotiation of the agreement?
I would probably refer that to my supervisor, Troy Russell, that will be testifying later, but most of it was done by legal, I believe.
Okay, so as far, I mean, legal staff's not testifying today, so I need to talk to Mr. Russell about the negotiation of the agreement.
That would be correct.
Okay. All right, I'm gonna try and publish that agreement because I just want to make sure we're all on the same page here. And that means I'm gonna have to try and share my screen, which I'm in the process of doing. And
Mr. Schlatter, if you can't find it, I have it.
did I do it?
You sure did.
Look at that. But except for now, it's made my little screen on Zoom really, really small for some reason. So whatever. We'll get this figured out someday. I can still see Mr. Dooling. Okay, Mr. Dooling, here's the commission's order approving the settlement agreement. I've published it May 24th. Settlement agreement is attachment A. It's the third page of this order. It has a series of paragraphs discussing the background of the matters at hand. And then we kind of get to the guts of the agreement here, the substantive terms. And so it's correct. Am I correct in my assumption that there are 45 wells that are the subject of this agreement? And those are spelled out in paragraphs A through G, 11A through G, I should say.
That is correct.
Okay. And as part of paragraphs 11A through G, it requires Ace Energy to pay fines totaling $4,500, correct?
That would be correct. Yes,
It's $100 per well, right?
that is correct. Yes.
And that was to be done by July 1 of 2022, and there's no dispute that Ace Energy paid that amount of money.
Not that I'm aware of, but I do not have the answer to that.
Okay, now the wells aren't actually specified anywhere in this agreement. They're made by reference to these various dockets in paragraphs 11A through G. Does staff have a list of these wells somewhere?
Yes,
You maintain a list of the wells, or someone from District 3 maintains a list of wells, which are in compliance, which aren't?
I maintain a database that has the wells that were on the settlement agreement and track whether they've been brought into compliance or not.
Have you shared this list with Ace Energy, or is it a practice to share these lists with the operators?
It is a practice to share the list with the operators.
Have you done that with Ace Energy?
I thought that I had emailed him a copy of that list at the end of July after we discussed the revoking of the TAs. But I did not find a email with the actual list sent to him. No,
So you have not shared your list with Ace Energy?
not that I can find.
Why not?
Must have been an oversight on my part. The 45 wells that were listed in this order, the operator had the knowledge of those 45 wells, and 7 wells were approved TA, so they did not go on the settlement agreement. So 45 minus the 7 or the wells, there was 38 wells left that were on the settlement agreement that had denied TA applications. But an actual list was not sent to the operator.
I'm just reading the room here. There seems to be a little bit of confusion as to what's in compliance and what's not. And wouldn't that be helpful for both parties, since it's an agreement, it's a two-party deal, to understand which wells are compliant and which wells are not?
None of the 45 wells were in compliance when this settlement agreement was approved. The settlement agreement states that the operator will file TAs for all 45 subject wells in this order. It also states that the wells that are denied TA status will be added to the settlement agreement. So the operator knew which 45 wells he needed to file CP1 applications for, because I received them. District received those applications for the 45 wells in this order. He also got knowledge that there were 7 of them that were approved TA status. So those wells did not go on the settlement agreement. That left 38 wells that he filed TA status for that were denied. So those 38 wells are the wells that are on the settlement agreement.
I understand, Mr. Dillon, and the 45 TA applications that were filed are exhibit F1 to Mr. Frieden's testimony, are they not?
I have not looked at the new F1. I did not get that till this morning.
Do you have any reason to deny that that's other than the fact that I screwed that up the first time, that exhibit isn't true and correct?
I would assume that those are the 45 original ones that he sent in for application. That is correct.
But as far as I know, nobody's disputing that Ace Energy timely filed the 45 TA applications, correct?
That is correct.
What's at dispute is which wells are compliant and which wells aren't, and that was just the purpose of my question. It seems to me like Ace Energy thinks some wells are compliant, staff thinks others are compliant, to the point of accusing Ace Energy of lying. And it seems like it would be helpful if everyone was working off the same list. Would you agree with that?
I believe everybody is working off the same list. Maybe I'm misunderstanding the question. There was 45 wells on the order. 7 of them was approved, so they did not go on the settlement agreement. That leaves 38 wells that are out of compliance that the operator has to bring 5 wells into compliance per quarter.
That's not true. 26 wells plus 7 were approved, and then they were unapproved. That's your testimony. I'm not
That is
trying
correct.
to trick you. I'm just saying if everyone was working off the same list, wouldn't that be easier?
Yes, I mean, we are working off the same list. Those 26 that were revoked would have never been approved if the operator would have not submitted falsified information. And I contacted the operator by email and also by sending that letter through mail and a phone call to discuss that with the operator. So the operator knew, in fact, that those 26 wells were on the settlement agreement and were not in compliance.
Mr. I'm going to move on past this. I think it's been established that you have a list. They don't have your list. That's all I wanted to say. That's it. Referring back to the settlement agreement, paragraph 11H, there's a legal term. This is the meat and potatoes of the agreement. These are the substantive terms. Would you agree with that statement?
Is this what you have drawn up here?
It is, sir. And this is paragraph 11H. It's kind of, I call it the meat, but this is the real guts of the agreement. This is what Ace Energy is going to do, what staff's going to do. This is the mutual obligations. Everything else was more or less background.
Yes, sir.
Okay. And so I just wanted to go through this and make sure that everybody understands everybody's obligations under this agreement. And if Mr. Russell's the right person for this, fine, just tell me. If it's you, you're assessing compliance. You've testified in length about compliance. I think you can handle this, but if not, let me know and I'll save that for Mr. Russell.
Okay.
So, in other agreements, compliance agreements, settlement agreements, whatever they're called, when a well is approved as compliant, it drops out of the settlement agreement or compliance agreement, correct?
That is correct. Once the well has been brought into compliance, it is noted as compliant.
And then it falls out of the agreement. And if something in the field happens with that well in the future, a new enforcement action is initiated on the part of staff, correct?
That would be correct.
Okay. And is that the case with this particular agreement?
If they brought a well into compliance, then you're saying that has no more bearing on this agreement, correct? Is that what? That is correct.
Okay, that's all. Yeah, so there are, it sounds like unquestionably 7 wells that are compliant are not part of this agreement anymore.
That is correct, because the TAs were approved in July.
Okay, and so that is the case with this agreement. Once a well is in compliance, it drops out and we move on to what's left on the list.
Yes, I mean, that was the original. That is how the list was constructed. to begin with, yes.
Okay. So now I personally wasn't involved in drafting and negotiating the terms of this agreement, but as I read it, there are essentially two steps to achieve compliance. Step one is the filing of the 45 TAs, correct?
That is correct.
And then staff is supposed to, and this is in this first sentence or first couple of sentences right here, I believe the big line where we go from step one to step two is where my cursor is right now. But after those TA applications are filed, then staff is to approve or deny those TA applications.
That is correct.
And we already covered this, but there's no dispute all 45 of those were filed on time.
That is correct.
You used a term in your rebuttal testimony that staff revoked TA status for some of these wells. Is there anywhere in this agreement that gives staff the right to revoke TA status?
The right would be under the regulation 82.3.111 under subsection C for right of denial. It's not listed in the actual agreement.
The right of denial is the right to revoke.
Well, yeah, the TA application never been approved and would not have ever had to been revoked if the operator would not have falsified the applications.
We'll get to the falsification issue, which is honestly, that's the first I've heard of this today. I don't know why that wasn't in your direct testimony. I think that's inherently unfair, but regardless, you used the term revoke not to talk about a well you denied TA status for, but one you had approved and then later revoked as being denied.
That is correct.
And the agreement doesn't provide for revoking of TA status, does it?
I do not see it wrote in that settlement agreement that way. No.
In fact, it says staff shall approve or deny these TA applications, correct?
That is correct.
Doesn't say approve and deny or approve, revoke, deny. It doesn't say any of that. It's bilateral.
I would agree. It says approve or deny.
Now, step two of this agreement is after we've had these 45 TA applications approved or denied, is this isn't as clear and there's a lot more language addressing this, but generally speaking, the idea is that these whatever's left needs to be brought into compliance with 82.3.111, the TA regs, at the rate of 5 per quarter.
That is correct.
And compliance with 82.3.111 means return it to production, plug it, or obtain TA status for the well.
Obtain approved TA status. That is correct.
Yes, staff approved TA status.
Yes, sir.
I noticed from here, there's a few nuances, and I'm wondering if you know the reason, and if you don't, that's okay. But one of the requirements is that any well returned to service or returned to production has to pass a CIT, which acronym for casing integrity test. Do you know why that's a requirement?
Yeah, a lot of these wells that we're testing are failing integrity of the casing. So we want to make sure that the casing is sound where we're not polluting fresh and usable water.
So, but we're talking about wells returned to production.
That is correct. You can have pollution whether a well is returned to surface or TA.
But that's over and above the ordinary requirements of the commission to obtain a CIT to put a well into service, isn't it?
All the settlement agreements that I've been dealt with has had that language in them.
Okay. I was just curious. I thought that was unusual. Was there some reason to believe that all 45 of these wells had bad casing and needed CITs? I mean, when this agreement was executed?
Uh, again, I did not draw the settlement agreement up, but just kind of knowledge, 17 wells were CIT'd so far, and I believe 7 of the 10 either failed or could not be tested because of problems with the casing. So I would say that sentence is probably pretty good to have in any agreement.
Okay. I've never seen it before, so I thought I would ask. The same kind of question, to obtain TA status, you have to do a CIT and file for 10-year TA application. Is the assumption here that there were several wells that had been shut in for more than 10 years? Is that why that's a requirement?
If you read about any settlement agreement, it has that language in there.
Okay.
I
didn't know that.
Yep.
Because ordinarily when you file a TA application, it's you show that you've shot a fluid level and it gets approved or denied without the necessity of a CIT or an exception application unless there's some complicating factor, correct?
Yes, I mean, as long as that's not the only thing is the fluid level. That, I mean, I don't know if that's what you're asking, but no, the fluid level is not the only thing that is needed for an approval of a TA.
Or you have to have a valid lease or things along those nature. But as far as ordinary day-to-day operations, somebody files a TA application, shows that the fluid level is not at service, it typically gets granted in the administrative course, correct?
Not typically, no. There's a lot more other things that need to be looked at before it's going to be approved or denied, not just a fluid level.
What else do you look at?
A lot. When's the last time the well was in service? That's where the 10-year exception comes in. Also, you need to look at how the well is constructed. If you send in a TA that shows a 10-inch surface with 2-inch casing and it's not cemented up, you're automatically going to have to do a CIT to make sure that that casing is sound, because there's no cement on the backside of the casing. You look at the fluid levels, you look at a lot of different factors. It's just not a fluid level. I believe your question when asked if it had a good fluid level, it was automatically approved, and that is not correct.
That's not what I meant to ask, but that's okay. I'm curious, when this settlement agreement was entered into, did you have any notion or idea how many wells you thought would pass or would initially be approved for TA status of the 45?
Not until I started reviewing the TA applications, no.
Because you ultimately denied 38 of the 45.
That is correct.
And it just seems like, what's the point of doing the 45 to begin with if nearly all of them are going to be denied?
Because first of all, the order states that, the settlement agreement states that, which was constructed by the operator's legal staff, the way I understand it. So I have a job to fulfill. However, if the commission orders an agreement, I have a job to fulfill the terms in that agreement. And the terms simply states that you will file a temporary abandonment form for all 45 wells.
So you don't know why that was a requirement, if that was the expected outcome. Is that a question for Troy?
I would ask Troy that question, yes.
Okay. Because Mr. Frieden testified he thought there'd be 3 or 4, and to me that makes a lot more sense with this obligation to file all these forms, that we would just skip to the point if they were all going to be denied. It seems like a lot of paperwork for no real practical purpose, and so I was just curious. So getting back to these 26 unapproved TA applications. So Ace Energy files all 45 of their applications. On July 12th, staff approved 33 of them, correct?
That would have been correct, yes.
So using arithmetic, 45 minus 33, 12. were denied or left over. Correct?
Correct.
And at 5 per quarter, we'd be done with the settlement agreement into this month, right? We'd had 5 in third quarter of 22, 5 in fourth quarter of 22, and 2 more to do this month.
I would say they have the opportunity should be, that would require actually bringing them back into service, plugging them or getting the proper paperwork.
Sure, but that if the agreement was performed as anticipated, that's what we'd be talking about.
Okay.
So in third quarter of 2022, staff suspended Ace Energy's license. There's some motion practice to resolve the dispute. Ace Energy says they are compliant, staff says they aren't. And ultimately, the commission ruled that 5 of those were indeed compliant, correct?
That's what the commission ruled. That is correct.
So we're down to 7. We've gone from 12 minus 5, 7 to go. 5 more are at issue today, right? We've got one that everybody agrees is producing. That's the Gale Mullen E43. But then there's the 4 Thornton wells that ACE says are compliant, that staff says are not compliant, right?
I would agree with the Thornton wells and the producing well. There's more than just the 7 that you stated, but I agree that the Thornton wells are not in compliance. That is correct.
Well, put another way, we're trying to count to 10. That was Mr. Kimbrell's opening statement, and we've at least counted to 6 so far.
Yeah, I would agree with that.
Okay. And I'll address those 4 Thornton wells with Mr. Russell because he provided some testimony on those. I'm not going to get into those with you. So that would leave 3 wells left on my math, 33 minus 5 minus 5. I'm sorry, 45 minus 33 minus 5 is actually 2, but I think that Gale Mullen well had originally been approved for TA. And so it's really 3 wells left. And those 3 wells were denied for being shut in for 10 years.
I don't agree with your math, the numbers.
What do you mean?
The 26 wells that you keep referring to are denied. They were revoked because the information were falsified and it should not have been granted TA approval. So 45 minus 7 is 30A.
They were granted TA approval. So we're 7 more. So we're 5 in the third quarter. So it was at least 1 in the fourth quarter plus the 4. And this is just for argument's sake. If nothing had been revoked, we'd be talking about 3 wells right now.
Objection. Argumentative. Mr. Schlatter is testifying. There wasn't even a question there.
It's arithmetic. I mean, I'm going down the list. 26 were approved. That's in the record.
Mr. Schlatter is making statements. He's testifying.
I'm allowed to ask leading questions.
That wasn't even a question, Mr. Schlatter.
If you could turn it into a question, Mr. Schlatter, I would appreciate it. Thank you.
Yeah, the question is, we had, and I'm just reciting the testimony. This isn't anything. I mean, we're in the last 5 minutes here. We had 26 approved on the 12th. 7 were approved, and there's no dispute about those. 26 plus 7 is 33. 5 in the third quarter. That's a commission order. 38. 5 more in the fourth quarter. 4 of those are at dispute, and 1 of those was counted twice. So we're down to 40. We're up to 42, and there's 3 left. Those are the Gale Mullen B40, the Underwood 6089, and the other Underwood 6089. That's 3 wells, correct?
With your numbers, that sounds correct. Yes.
And those were denied for being shut in for more than 10 years. And so they need to pass CIT and have a 10-year TA exception application filed, correct?
All 38 wells that are on the settlement agreement, it states in the settlement agreement has to pass CIT, not just pick and choose which ones you want to test.
that would be an option for wells that are more than 10 years shut in, is to obtain a CIT, pass CIT and file a 10-year exception application. That's an option for compliance under this agreement.
That is correct. It is a option under this agreement.
Okay. Let's talk about these 26 wells, the elephant in the room, if you will. I think I'm still displaying the settlement agreement for some reason. That's my fault, but I do want to look at your letter again. Okay, this is exhibit RD1. So these are the 26 wells here that were approved on July 12th of 2022 and then were unapproved on July 29th for various reasons set forth in this letter, correct?
That is correct.
Why were they approved in the first place?
They were approved by the information provided on the application by staff.
Did you approve them?
No, sir, I did not.
Did somebody you supervise approve them?
I do not supervise anybody. I'm program manager, but as far as supervising, no. But it was a field staff ECRS that works in my office approved these.
So let's talk about these first 20 wells. You said that the wells exceed the 10-year shut-in date. You did some rebuttal testimony on this. The 20 wells at issue are spelled out in paragraph 1 of your letter. The TA applications all have dates that are within 10 years. And then you went through and you said that you looked at the dates on older TA applications, all of which I believe are December 1st of 2010. Is that correct?
I believe that is correct. I'd have to go through each one individually, but I'm pretty sure they all on this list were all December 1st of 2010.
Okay, and you know that Ace Energy has not operated these wells since 2010, correct?
I know for a fact that the district office has never been notified that the operator has returned them to service. And I'm not sure why an operator would continue to file a temporary abandonment form if he had had the well in service.
I'm going to move to strike that response as non-responsive.
I object. I believe that answered the question that was asked.
In what way did that answer my question?
You asked, how do we know that the wells were shut in for more
No,
than
I
10
didn't.
years?
I asked if he knew that Ace Energy did not operate the well in 2010.
And Mr. Dooling replied that
No, he did not.
he replied that he knew that it hadn't been shut in because Ace Energy hadn't told them that they had not produced the wells. That's how he knew. That was answering the question.
I'll allow the response.
Mr. Dealing, I'm going to answer my question again. You know that Ace Energy did not operate these leases in 2010, correct?
I know that the applications say they did not, and I did not. The district office did not receive any communication from Ace Energy that they had returned any wells to service.
So, I mean, I believe, and Mr. Frieden can clarify, but Ace Energy hasn't operated these leases since 2014, correct?
I do not have that information in front of me. I do not know what Mr. Frieden states.
Well, other than looking at an old TA application, what research did you do to establish that Mr. Frieden is lying in his most recent set of TA applications.
In his most recent set that I received on March the 3rd of this year,
The ones that were approved, yeah.
well, the ones from March haven't been approved. So that, are you
No,
talking
the
about?
the 26 wells that were approved, there are 20 of which are now unapproved for 10-year TA. What, other than looking at old TA applications, what research did you do to establish that the dates that he put on that form weren't accurate?
The research that I found on TA applications that the operator signed off and said is the only thing I did research on, because that is what the information they provided district staff.
So you picked the older date of the two that were provided.
I picked the date that has been provided for several years. I could have printed off TAs from up to 10, probably back to 10 years ago with the same date on them, Mr. Slatter. I just provided the most current one that was approved with the 2010 date. It's been approved for several years. The operator has filed TAs on these wells for several years with the same TA shut-in date. And then all of a sudden, when the date is no good no more, it's changed. So yes, that is the research I did.
Did you
'Cause
talk
that
to
was-
Mr. Frieden about which date is actually correct? Did you call
No,
him?
sir, I did not ask him about that date. No.
Did you ask to look at his well files to see if there was anything showing that they'd produced since then, or that that was the actual shut-in date?
Nope.
So basically, they picked the date that would cause the well to not be in compliance under the agreement.
That is not correct. And I do not like that statement, because you act like that I wanted all of those to be denied, and that is not correct.
So you understand that staff has the burden of establishing when of proof here today, right? We talked about that in opening, that it needs, if it believes this well was shut in for more than 10 years, it should come forth with some proof.
I believe we have.
And that proof is you looked at an old TA application filed by the operator.
I looked at information provided by the operator is correct. That is is the reason I revoked those applications.
And if Mr. Frieden were to testify today as to how he came to the conclusion of the correct shut-in date, would that satisfy you?
I imagine my attorney would object for hearsay. I don't know. I'm not an attorney, but no, it would not satisfy me.
So you wouldn't, even if you asked Mr. Frieden,
Because we could go to
Why?
these wells today and they're still not in production.
that's what a TA is for, isn't it?
So, I mean, that would satisfy me if we could go there and, man, these wells are producing like they should be. That would satisfy myself, district staff, commission.
But
The
they're
whole
not
9
producing,
yards.
these are TA applications, and so he files a TA application because the well's not producing. One of the questions
correct.
asked is, what's the shut-in date? You know, we had 20 that said the same date, now we have 20 that have variable dates. You're calling him a liar over that, and I'm wondering what diligence you did before you made that accusation.
I reviewed the information that was provided and has been provided for several years. The operator has not reached out and notified district staff that these wells were ever returned to service. So there's no reason that you would put a date of 2019 as being in production, but you filed a TA just 6 months ago saying it was still out of production with a 2010 date.
What if the reason is because that's the correct date and that's true? Is that a good reason?
Well, what I guess the hardest thing for me to answer is there's several TAs. I can't answer this with a yes or no answer. There's TAs that were approved in 2020 with a shut-in date of 2010. There was denied in 2021 because the shut-in date was in 2010. Then they have a date. It'd be easier if I find it.
I mean, Mr. Dooling, there's no dispute that there is two different dates on these applications. I don't think you need to explain that. I'm just wondering what you did to verify what was actually true. You've alleged they've falsified government documents. That's a very serious allegation. And if it's just look at old applications and not do any legwork beyond that, that's all I'm trying to establish.
Well, I can tell you on the recent TA applications that the operator sent in on March the 3rd of 2023, he listed fluid levels of 197 feet when we just did the CIT that got fluid level, it's full of surface. So I'm not sure. I mean, I guess since staff was there and witnessed the fluid level at surface, that even though I guess it could be wrong that he got a fluid level of 197 feet. So I apologize for not a yes or no answer, but I believe that staff has done plenty of legwork and has tracked documents. And the operator could have picked up a phone or emailed staff and said, hey, these wells were in production, but he did not.
And we're here today on staff's motion, not operator's motion. This was initiated by staff. You had an opportunity to make that call before this motion was filed, and you already testified you didn't do that, correct?
The reason we are here today is because they were supposed to bring so many wells into compliance, and they have not.
The posture of this hearing today is a motion to suspend operator's license. That's the posture of the case today.
I understand
And-
that because the order says it would be suspended if they do not fulfill the terms of the settlement agreement.
And that's what's at issue today.
I agree.
I'm not trying to argue with you. I'm just trying to establish if you did any other work before you accused him of falsifying records and lying, any other work other than look at old TA applications and extrapolate your personal beliefs. Is the answer to that question still no?
I'm just gonna satisfy you and say no.
All right, let's set aside these 20 wells for now, because there's also 10 that have for sure passed casing integrity test. Correct? And that's in your testimony.
That is correct. There is 10 that has passed CIT testing.
And so shouldn't all 10 of those be eligible for TA status?
They are eligible for TA applications. That depends on other circumstances where they'll be approved or not. And most of that is these wells have not been in production for several years back, even though you seem to claim the operator says they have been. But that is not the only thing. That is just one part of getting them TA status.
Following the application is what would be necessary to obtain TA status.
They would file they'd file a CP 111, or if it's been shut in with over 10 years, they could file for the exception of the 10-year rule.
And hasn't operator filed TAs for these 10 wells that have passed CIT? They're in queue.
That is correct. They filed them on March the 3rd of 2023.
And I'm going to call up for you Exhibit F4, which is a computer screenshot of Ace Energy's K.A.R account showing those 10 applications have been submitted and they're just waiting on staff to approve.
Okay.
And we'll go ahead and offer that at the end, but this is Exhibit F4. Since they passed CIT, I know you said you hadn't had a chance to look at them, but assuming everything checks out, could these wells now be construed as in compliance under the agreement?
I would have to review the application before I can answer that question.
But if you approve them for TA, we have 9, correct?
You have 9
There's
TAs.
9 TAs, and I should clarify, one of the wells that passed CIT is back in production, is already in compliance under the agreement. So there are 9 left. We filed TA applications. Ace Energy filed them. They're waiting on staff's approval. They've passed CIT, assuming there's no issues with the application. If staff were to approve those, would we have 9 more wells in compliance?
if you want to assume that is correct, I mean, yeah, I mean, that's math, 9, that would be 9 more.
Okay.
If the applications were approvable.
One of the reasons, and I'm going to jump back to your letter here, RD1. One of the reasons here in paragraph 3 was, well, that casing information does not match well construction. Does that mean that, and I'm going to use some layman's term here, there was a typo in the TA application on the well casing?
I would have to go back and review it, but I believe it was not even close to the way it was constructed, but I would have to go back and pull that documentation.
But assuming that's corrected to the casing matches, the typo is corrected, would that well not be eligible for TA status?
The 1325,
The what?
I'm guessing you're talking
Oh.
about the Thornton 1325.
I'm sorry. Yeah, the well identified in your letter under paragraph 3 is the Thornton 1325.
I would have to pull that. I mean, I know that was one of the reasons for the denial. If that was the only reason, then there's a great chance that that one could be approved, but without going back and looking at the application, I would have to look at it to say for sure.
And I believe that's attached as operator's exhibit F2. Assuming we have the right exhibit there, is the 1325, the TA application for that was recently submitted. So let's say we got the casing information correct this time, that one could be approved for TA status.
Possibly, yes. I mean, I would, like I say, I'd have to review the application. I would hate to say yes for sure today and then it could not be, and then you say I lied. So
no, I wouldn't do that to you. But
Mm.
that's 10, hypothetically. 2 of these wells on paragraph 2 of your letter, exhibit RD1, are for surface control. Does that mean they need a swedge or something else to plug
that's
off the
correct.
well?
That's
Okay.
correct. They're open casing.
So assuming swedges were put on these wells, they're otherwise good to be approved for TA status?
Yes. I mean, as far as I'm going to assume here, that was the only reason. So after investigating, we would look at that again, and that was the only reason. And the operator has since done that in the last month, then they possibly could be approved.
Okay, so that would be 10, 12 wells that you and I talked about that could be approved for compliance under this agreement. Now, the last one, paragraph 4 here, is oil wells that are currently plumbed for injection purposes. And I'm going to be honest, I have no idea why that would be a basis to deny a TA application. Can you explain that?
Well, there's a well type on a TA application that says oil, gas, water supply, or other. They are oil wells. They were constructed as oil wells, have always been producing wells. They were marked oil wells. If they are plumbed for injection purposes with fluid going down them, then obviously that's not a producing well and should not been TA'd under oil, even though they weren't permitted for injection purposes. However, that was not the only reason. Those wells have also been TA'd since 2010. And so there was numerous reasons for those, but that was the biggest concern was
They're like
were
arguing with each
plumbed
other.
for injection.
half the time.
Excuse me, I'm sorry. Jaden, thank you. All right, continue.
Sorry, Mr. Dooling, you got interrupted there a little bit. Do you want to restate your answer? There was some interruption on Zoom, and I think it might have garbled the record. If you
Okay,
wanna-
I'm sorry.
No, it's not your fault.
Those three wells, that was my biggest concern and issue, that those wells were being used for injection purposes. They're oil wells. That was not the only reason for denial. They've also have been shut in for more than 10 years.
Okay. Those 3 wells have all passed CIT, correct?
Uh,
We're talking about the Gail Mullen C43, the Gail Mullen I-43, and the Underwood 6R90. Those have all passed CIT according to your testimony.
Yes, I believe. I just wanted to make sure that I had
So
those in front of me.
We file a 10-year TA exception application. Those are good to be approved.
Correct.
Okay, so we're up to 15 on just you and me wrapping here today. We've got 15 wells in compliance with some pretty
No,
perfunctory paperwork, assuming everything
I
checks
would-
out.
I was gonna say, I wouldn't say they're in compliance because
I'm not trying to put words in your mouth. I'm just,
Thank
for
you,
the
sir.
sake of argument, don't let me do that. But I mean, that's 3/4 worth of objectives right now. I feel like this is something that maybe was better handled in the field than in an evidentiary hearing. Would you agree with that statement, or is this the proper form to sort of sort these things out?
I think there's deadlines that are supposed to be met. And yes, today we're about 3 months after the time frame of when these terms were supposed to be met. The operator had plenty of time to do these terms during those timetables, which he failed to do. So I'm not going to agree with that statement from you.
I mean, would you agree that the objective of the settlement agreement is to bring all of these wells into compliance with commission regulations?
I 100% agree with that.
And so we're getting there, right? I mean, that's the objective. We want to get there over and all and above everything. And, you know, the hammer of suspending the operator's license is a pretty serious hammer, and I understand your point, but it seems like a lot of these issues are more disputes about whether something's in compliance that could be properly handled in the field and not necessarily at a trial. I mean, how much time have you spent preparing pre-filed testimony, testifying today? I know it's not fun to testify. I mean, just ballpark, how many hours have you spent preparing for this?
Objection, that's outside the scope of this hearing.
No, it's not. We're having a hearing, and I'm just curious.
Mr. Dooling, if you can give an estimate of your time, that would be fine.
I mean, I'm going to just estimate 40 hours. I do not know without going back and looking at timesheets.
40 hours is a lot of lease inspections, isn't it? A lot of phone calls, a lot of emails.
40 hours is a lot of time, yes, but I try to be as prepared as I can to present the facts of the case. So yes.
I mean, in page 3, line 6, you testified your job duty is to generally try to resolve compliance issues. What have you done in this docket to try and resolve these compliance issues?
I've done quite a bit, believe me or not. Matter of fact, the operator would have failed to even get all 45 TAs sent in before the deadline if I wouldn't have caught and noticed that he didn't have them all turned in. I called him, discussed that with the operator. I mean, you kind of make it put to a point to where I want everybody to fail, and that's not correct. I do everything in my power to make sure that the operator strives and does the right thing. But ultimately, I can't do it for the operator. He has to do it for himself. So I've reached out to the operator numerous times. He's reached out to me numerous times, and we have discussed several different things throughout this settlement agreement. So I feel like I have done a lot to make sure that to try to help have this settlement agreement and not be here today.
Give me just a second here. Make sure I got covered everything. And I think that's all I have for you, Mr. Dooling.
Okay, thank you, Mr. Schlatter.
Thank you.
Okay, I'm looking at the time, folks. We've been going an hour and a half. We're going to take a 5-minute break because I know there are commission questions and this witness probably needs a break. Just a reminder, Mr. Dooling, when you come back, you will still be under oath. So we will, it's 11:34. Let's come back at 11. Let's make it 11:45. Give everybody a few extra minutes. Thank you. We're off the record right now. Okay, we are back on the record. And Mr. Dooling, again, I'll remind you, you're under oath. And at this point in time, let me go to my notes here. We'll go to commissioner questions. And I'm looking here, we've got two more witnesses. It's 11:45. I have a feeling we'll be breaking for a 30-minute lunch break and then we'll return, but we'll try to get through, well, my goal is to get through this witness and possibly, well, at least this witness before we break for lunch. So Commissioner French, do you have questions?
Well, that was a lot of information. I'm not sure whether I have any questions. Why don't you go to Commissioner Keene first, and then I'll see if I have any follow-ups.
Absolutely. Commissioner Keene, I'll turn to you.
Thank you. It's still morning. Good morning, Mr. Dooling.
Good morning. Good morning, Commissioner Keene. How are you?
Just fine. A few questions for me. Let's kind of cut to the chase pretty quickly. Under settlement agreements or compliance agreements between operators and KCC staff, which of those parties has the obligation or burden to comply by taking affirmative steps that are set out in those agreements?
The operator.
The operator.
Mhm.
Okay. In your opinion, with respect to the wells that are subject to this docket, as of right now, how many of these wells still require casing integrity tests?
Let me do the math real quick. There's still 15 wells that needs to have CITs done on them because the 9 EOR wells on the Thornton lease were just recently MIT'd a month or two before the settlement agreement was signed. So we did not feel like the operator needed to redo a new CIT for those. So those 9 wells, we decided did not need a CIT because they previously passed an MIT just months before the settlement agreement was signed. So there's still 15 wells that need CIT.
Okay, if I do 15 plus 9, that's 24.
That's correct.
How does that reconcile, Ryan, with the 38 that's been thrown out here previously?
Well, there was 38 original ones, and you take off the 9 EOR wells. I believe that's 27. And then there's 10 that he has passed CITs. So that's leaves 17. And there's 2 wells that are failed and remain in failed status. So that's 15 wells that have not been tested.
Okay, good. I think I have the math straight now, at least in your opinion. All right. I appreciate that. With respect to these casing integrity tests, tell me about that a little bit. Is there some staff discretion regarding the need or necessity to conduct these tests?
I believe it is a good thing, especially on these older wells, because we are finding a lot of wells that are failing casing failures, that on wells that we've had CIT. We have done, let's see, on this one, there was 12, there were 17 wells scheduled. I believe my math for CITs on this settlement agreement. 10 passed, 2 failed, and 5 they did not hook up to because there was either holes in the casing at surface or wellhead construction was not allowed to be tested the day they were there. So 7 out of 17 wells were either failed or could not test because they would fail. So I think it's a good statement to have in any settlement agreement, because we're eliminating a lot of wells that has potential casing problems that's creating environmental problems with fresh and usable water.
Okay, is it correct that at least 2 of the factors that would cause the state to ultimately require a casing integrity test would be the age of the well and the static fluid level?
The fluid level is one thing that we definitely look at a lot to see the static fluid level and the age of the well. You see, I'm going to answer the yes to your question. Sorry.
Okay, beyond those two criteria, are there any others that are major big ticket items that say or indicate to you that this well to protect the fresh water requires a casing integrity test?
Yeah, definitely the construction of the well.
Okay. And by that you mean what?
The construction is probably, to me, one of the main first things I look at any well is how it's constructed. Is it an alternate 1 well? Is it an alternate 2 well? When was the well drilled? That to me is the main, the very first thing I look at is whether it's alternate 1 or alternate 2 and how the well is constructed.
What's an alternate 1 well?
Alternate 1 well, there is no cement. It's not fully cemented on the backside of the casing.
And what's an alternate 2?
Alternate 2 means that they're cemented from bottom to top on the backside of the casing.
Okay, with alternate 1, correct me if I'm wrong, meaning that basically the backside of the casing has not been cemented to surface, but it has probably been cemented, at least it was the intent to cement it above the level of wherever the perforations were going to be placed.
Correct.
Okay. Okay, let's talk about the wells now that are subject to this docket using that background. Isn't it true that passing a casing integrity test is but one of the requirements to be fulfilled before granting a TA status?
That is correct in the terms of this agreement.
Okay. What are the other requirements generally?
In this agreement or just general? I mean,
as it would apply to these wells in this particular docket.
The first thing is whether they're going to file for a TA or return the well to surface, it says it needs to pass the CIT. If they're going to plug the well, obviously we wouldn't require CIT because we're going to solve a problem if there is one.
Right.
Once the CIT is done and it's passed to the CIT, then they have the option of returning the well to service or filing a TA application if the well is in the time frame to have an application. If not, they can file an exception to the TA rule.
Okay. So with regard to the operator's wells that is subject to this docket, are you concerned with other compliance issues beyond the CIT that may have some bearing on whether or not the TA application should be granted? If so, what?
There's a lot of these wells have not been, does not appear to be produced for years. They would not qualify for a regular CP 111. He would have to file a 10-year exception to be able to get TA status.
So it would be in part, I'm surmising what you're saying here. It's the consistency between all the documents that may have been filed by the operator historically and the attempt to conform that to the requirements of the reg.
That is correct.
Let's talk about the concern that you had expressed, and I think that was brought out not only on the rebuttal testimony that you provided to Mr. Kimbrell, but it was also alluded to in the cross-examination by Mr. Schlatter, and that is certain wells that you're contending had filed for TA status as producers, but actually were plumbed for injection upon inspection. Tell me a little bit about that. How do you tell this plumb for inspection, plumb for injection? Pardon me.
The wells, and we have documentation with pictures. I don't have those field reports in front of me, but the well was hooked up to a flow line, and the valves. Usually, an injection well has a check valve, and a check valve prevents fluids that, if you're not having the well in use in a certain time, if the well pressure's up and comes back up, the wellhead, if it's connected, it cannot go through the check valve. That's what the check valve is there for. A check valve only allows fluid to go one direction. These wells, if my memory is correct, had valves, check valves with the fluid only going towards the casing. So there's no way that could be a producing well because fluids could not come from the wellhead up. It would be stopped at the check valve. So that is one of the main priorities that we look at. I know one of the wells that were on location, it was 100 and some degrees and the lines was cold. If you're not using the well for injection purposes, the line should not be, should not be able to fill cold fluids. So that was the two things that were noticeable on some of these wells.
Was there an absence of artificial lift?
I'm sorry?
Was there an absence of any artificial lift? Were there no jacks there?
No, not on those wells.
Was there electricity laid from a nearby transformer to the vicinity of this well to operate artificial lift?
I cannot answer that question.
Okay.
It might be in the reports, but I'd have to pull the reports and look at those.
Okay. All right. One final question then that kind of dovetails back to the first question that I asked at the beginning of my cross of you. And that is, in your opinion, as between the operator and the KCC staff, who has the burden to demonstrate compliance with the terms of the settlement agreement in this docket?
I believe it's the operator. I mean, we don't want any operator to fail, but the operator has to fulfill the obligation of doing what the settlement agreement states. And upon all the inspections, we have not found that the operator has done what he claims he has done.
Okay. And so in fairness, with respect then to the staff under the settlement agreement, what is your obligation with respect to the terms of this settlement agreement?
My obligations are to track and, have open lines between staff and operator, but, and document everything that the staff finds. And if those findings do not fulfill the obligations, then let legal staff know. And I mean, that's why we're here today.
In sum, are you saying that it's an obligation of the staff to determine whether there has been operator compliance with the terms of the settlement agreement?
Is it staff's responsibility?
Is it a responsibility of the staff to ascertain whether there has been compliance by the operator with the terms of the agreement?
Yes, I mean, that's why we do inspections to ensure that the operator is actually doing what he has reported to the district office that has been done. I mean, if an operator calls and says he has 3 wells back into production and staff goes out there and there's 3 wells going up and down, automatically we enter our database that these 3 wells are brought back into compliance. But if staff goes out there and operator says, well, we've got 6 wells in compliance, and you go out there and 4 of the wells are open to the surface, nothing hooked up to them. No, if they're injection wells, they're not even connected to flow lines. They're not shut in. If they're producers, they don't even have jacks or anything on them. Yes, it's our responsibility to confirm that the operator is actually reporting that their wells are in compliance. So, I mean, I don't know if that answers your question.
Thank you, Mr. Dooling. I appreciate your responses. I have no further questions for this witness.
Thank you, sir.
Thank you, Commissioner Keen. I'll turn to Commissioner French. Questions?
No questions.
Okay, thank you. Good morning, Mr. Dooling, or I guess it just struck noon here. Couple of questions. Is it real common to have these agreements like we signed with Ace Energy to get wells back into compliance?
And I believe I heard you right. You asked if this was common.
Yes,
As far as settlement agreements,
yes.
I believe we're seeing more and more settlement agreements that are presented to the commission. Well, there's, a lot of difference between settlement and compliance agreement. Compliance agreement, there's a lot of district involvement with the operator. The operator is usually forthcoming saying, we've got this. So we sat down and try to construct an agreement to benefit getting compliance on those wells as quickly as possible and then present it to the commission for approval. Where a lot of times a settlement agreement, there's not as much, district interactions with a settlement agreement. It's more interactions probably between both legal teams.
Okay. Have we entered into a settlement agreement with this operator before, or a compliance agreement, either one?
There was one other settlement agreement with this operator previously that has not been 6 months ago. I think it was completed. It was for one well. It was a settlement agreement for one well to bring one well into compliance, and they did not fulfill that date. However, later on, they did get the well plugged, and so the well is now in compliance, but it was after the compliance date.
Okay, thank you. Is Ace operating, are they a new operator in the field?
No, Ace Energy has been around. I would have to go back and look. I mean, I'm going to say they've probably been around 20. I don't know. Mr. Frieden can probably tell you exactly. I'm 2014, somewhere in there. I mean, I'd say they've been here for at least 10 years in business in Kansas. I've had a lot of interactions with Ace Energy throughout the years when I was in the field, and obviously now as compliance officer.
Okay. And as far as owning these leases that are the subject of our discussion today, have they been operators of these for a period of time?
Yes, ma'am.
Okay, so they should have knowledge of what's on that lease?
They should. Yes.
In terms of the outreach to staff by the operator is, how is that mainly conducted? Through text, phone call, walk-in? How do you normally communicate? Email?
It was originally a lot of communications by phone. Since I would prefer probably email going forward. Would be probably the best route.
Okay.
But there was a lot of communication between the operator and myself prior to the settlement agreement, during the settlement, the first month of getting everything finalized, and then even afterwards trying to get the what wells that had to be brought into compliance first. There was a lot of communication by telephone, some by email. But most of it was done by telephone.
Okay. And what is the date on that settlement agreement?
The settlement agreement, I believe, was actually signed by operator and ordered in end of May, with the terms being stated that, they had to have all the 45 wells applications turned in by July 1st. And then staff had until end of July 31st to either approve or deny the TAs that were submitted on those 45 wells.
Okay, and I believe you testified earlier that you were the one who nudged the operator to say a due date's coming up. You need to get everything submitted. Is that correct?
That is correct. The operator submitted majority, and I want to say there was only one. There might have been 2 wells, but I know for sure of one. What had happened, the operator filed the wrong well. It was I think it was the same well number, but it was the wrong. Actually, there was 2 wells, the same API number. I reached out to him and said, "Hey, your deadline's only a few days away. We're still missing these TAs," and he submitted those TAs.
Okay, so Mr. Schlatter seemed to have a lot of conversation with you about, hey, we're just wrapping here and we've already got a lot of these resolved. And then Commissioner Keene said the onus, asked you about where's the onus of communication to ensure that the settlement agreement terms are met. Can you repeat for me from, let's just go from July 1 to a few months out. What is the bandwidth of your communication with the operator versus the operator's communication with you? Do you have a lot of communication with them, or are they initiating during that time frame after the settlement agreement was signed at the end of May until here we are today?
Most of the I mean, I would say that I reached out to the operator. The operator did reach out to me, but I believe a lot of it was because of field staff explaining stuff in the field he did not agree with, so he would call me. And that's why I say going forward, I'm going, going forward, emails is probably the best way for this, because sometimes exchanges seem to get heated and they don't, Mr. Frieden don't always agree, or I don't know if he agrees or understands what I'm trying to explain, that we have to get accomplished. And I seem to think a lot of times those conversations just end with what he's going to do, what he thinks it says. So that's why from now on, I think email is probably the best route. So that way each of us can respond in a kindly manner.
Okay. So in terms of, I'm thinking how to phrase this. I think Mr. Schlatter was trying to understand that, or to have you say that in terms of your research into the TAs, that perhaps you had not done your due diligence in investigating beyond a filed piece of paper from the operator with a certain TA date on. What was he trying? What else were you to do beyond looking at the record that is in Kohler related to what the operator had sent in at some point in time, stating that this is the date that XYZ occurred? What else is there in terms of research that staff is supposed to be doing?
I don't know the answer to that. I'm guessing that I will be, if there is, I will be inclined to know it after today. But staff investigates and deals with a ton of paperwork every day. I mean, we probably have 1,000 of these CP 111s a year come in. We rely on the operator to report as much, the accurate information as possible. And I don't understand if for years it becomes the same date and then all of a sudden the date ends and the date changes. And there's been no reporting to district offices that the well had ever been put back into production. I don't know what other research I can do. I've done some research on the gas wells, and I can tell you that gas wells on KGS, the production records are different for gas wells than they are oil leases. If you sell oil on an oil lease that has 40 wells and only 10 of them are reported for that production, then obviously, there's 30 wells out there that's inactive. The gas well is usually per gas well, and those are a lot easier to access off a KGS per well basis. So I do not think I've answered your question, and I apologize.
I'm just trying to find out. He seemed to imply that there was additional research that should have been conducted by staff into the matter. I'm just trying to find out what that research would have been beyond going back and looking at what the operator submits into Kohler as their work process and their completion date or whatever the form is. And so, yeah, you're right. There's a KGS website to see what sort of production was done or not. But I'm just trying to really determine, is there any other methods of research that is availed to staff?
Not that I'm aware of.
Okay. All right. Thank you. Those are all the questions I have. And so I will turn back to Mr. Schlatter for any redirect.
Chair Duffy, would I be able to do redirect?
Oh, I'm sorry. Yes, Mr. Kimbrell. I apologize.
Thank you. Thank you. So Mr. Dooling, Mr. Schlatter was talking about staff having a list of wells that were in compliance or not in compliance. Did Ace Energy or anyone associated with Ace Energy ever ask for you to apply, to supply them with any kind of list like that?
No.
Is it an operator's duty to know which of their wells are in compliance and not in compliance with commission regulations?
It is.
Mr. Schlatter seemed to imply that once a well is approved for a TA, that it automatically drops off of the settlement agreement. Is that your understanding as well?
My understanding, I don't know if he was talking about the original well that was approved in that month's time that we had for this settlement agreement. But in a normal compliance agreement, which I know is totally different, if there's a well on a compliance agreement and the operator brings that well into compliance, then that well is in compliance, and it can no longer be part of. I mean, you cannot let a well go out of compliance and bring it back into compliance and count it twice.
Okay.
So once it's brought into compliance, it is no longer part of being able to count towards another objective.
So the crux is that the well has to be in compliance to drop off the settlement agreement. Is that correct?
That is correct.
So for the 29 wells with revoked TA status, were they ever in compliance?
The 26?
Oh, sorry, I apologize. 26 wells that were revoked, were they ever in compliance?
No, sir.
So they wouldn't drop off of the settlement agreement, correct?
No, because really the settlement agreement's a little different. I mean, those wells weren't actually on a settlement agreement until they was in denied status. Once they filed the TAs, it says whichever ones were denied will be put on the agreement. Those wells were never in compliance and are still out of compliance, majority of them.
Okay.
So the answer is no. Or yes, they're never in compliance.
Thank you. So when you sent that letter saying that those wells had revoked TA status, did anyone from Ace Energy reach out to you and say, hey, we have production records showing that these wells actually were producing? Did they show you any information to suggest that those wells had been shut in less than 10 years ago?
No.
Okay. When an operator has TA'd a well and they bring it back into production, do they have a duty to inform district staff of that fact?
Yes.
Did Ace Energy ever inform you that any of those wells had been brought back into production?
Well, they sent a couple emails, saying they brought. Are you talking about those 26? I mean,
The 26 wells that had been revoked. Yeah. Did Ace Energy
Not-
ever tell you that those have been brought back into production?
no.
If we could just go back, since there was so much discussion about whether the TAs themselves could show whether wells had, whether false information had been supplied on those TAs or not. If we could go back to the Gail Mullen number 41 approved TA 7/14/2020, Mr. Myers.
Yes, but one moment. The Gail Mullen, which,
Number F41 approved TA 7/14/2020.
yes, hold on. Actually, hold on a moment longer. My computer is giving me an error when I'm trying to pull it up. So I'll get it, but give me a moment. Okay. My computer is working again. Here you go.
If we can, yeah. All right, thank you. So, Mr. Julian, I believe we established earlier this TA was filed in 2020. Is that correct?
That is correct.
And what is the shut-in date that was put on there?
12/1 of 2010.
All right, and then Mr. Myers, if we could go to the Gail Mullen number F41 approved TA 7/12/2022. And so this one was filed in 2022, correct?
That is correct.
And what's the shut-in date there?
12/1 of 2013.
So on the TA that was filed in 2020, that had a shut-in date of 2010, since it was filed in 2020, shouldn't Mr. Frieden have known that the well was actually shut in 2013, if that's when it was actually shut in?
Yes.
So one of those dates is false, correct?
That is correct.
So you don't need to do additional research to find that there was false information filed by Ace Energy. Is that correct?
Yes, I agree.
All right, thank you. We can bring that, take that down, Mr. Myers. Mr. Schlatter mentioned several new TAs that have been filed March 3rd for several wells. I think we discussed a bit that those in my rebuttal, so I just wanted to make sure that we were all on the same page. So those wells that were filed March 3rd, those TAs, you have had an opportunity to look at those TA applications, correct?
Briefly, yes. I mean, I have not been able to look at them and approve or deny any of them because they just came in, I believe it was last Friday. But I briefly looked at them.
And in briefly looking at them, are any of them do you believe are going to be approved?
I do not believe so, no, just because of the fact that these wells have been shut in for more than 10 years. And he's going to have to file an exception to the rule. And, you know, it's not only that, I mean, it's the fluid levels that we take reporting very seriously. I mean, we did CITs on all these wells. We know what the fluid level was when we did CITs. I mean, you would think that you would be able to write or be able to put the fluid level correctly on the form that what it was, you know, when we did the CIT a couple months ago, not 140-foot difference.
Okay. Just for the sake of argument, let's say that all of these TAs get approved. Would that go towards fulfilling the deadline of December 31st, 2022 for the second quarter?
It would bring wells into compliance. I mean,
Sorry, let me ask that
the
question again.
deadline was. Oh,
Oh.
I'm sorry.
Sorry, so if these TA applications were filed March 3rd, would they fulfill the December 31st, 2022 deadline?
That deadline was not fulfilled. It's already gone and passed. I mean, it just took us 3 months to get here today, I believe.
Thank you. Just kind of a general question. Why exactly are there deadlines in settlement agreements?
The main reason there's deadlines to make sure that the operator is continuing to, you know, before this settlement agreement, he would have had 30 days to bring all these wells into compliance. And the settlement agreement gave him extra time to bring certain portions, wells, 5 wells per quarter into compliance instead of bringing 45 or 30, you know, 38 that was left over into compliance within those 30 days. The deadlines are set in place to make sure that the operator is actually striving to bring wells into compliance. If we didn't have a deadline for anything, we would never have an end to any agreement.
Thank you. I have no further questions.
Thank you. Mr. Schlatter, I'll turn to you.
Yeah, just a couple questions. Thank you, Chair Duffy. An operator thinks he's in compliance, and the first time he finds out he's not is a motion to the commission to suspend his license. What are we talking about here? We keep bringing up this idea that the operator is supposed to know he's in compliance. Operator tells staff he's in compliance. Staff files a motion to suspend his license. Is that ordinarily how that works?
The operator emailed district office saying that he had brought in certain wells into compliance by returning the wells to service. You know, an oil well you have to have a way to get the oil out of the ground when you show up and there's no pump jack, there's no 1 inch in the hole, it's just a well casing sticking there. It's kind of hard to say that well is returned to service.
Did you tell him that before you filed the motion? That's what your belief was. Did anybody? I mean, we keep talking about this concept of the operator should know he's in compliance. The operator should know he's in compliance. Third quarter, we have motion practice on whether the operator is in compliance. Fourth quarter, we have an evidentiary hearing as well. There's clearly a disagreement as to compliance. I want to know is the first time he finds out it's compliance is when it's escalated to legal. And is that how staff conducts its business? That's a simple question.
I guess I'm a little confused. I mean, the operator reports to us what wells that he brought into compliance to fulfill his quarterly objective.
The implication being that he thinks he's in compliance.
Well, you know, it's funny because field staff for Ace Energy was out there the first quarter when staff was out there to inspect. And even the field staff for Ace Energy knew that there wasn't 5 wells into compliance. So.
Were you there?
I was not there, sir.
And how do you know?
Well, because field staff.
I want to know the answer to my question, which is, Did you tell him that you disagreed they were in compliance before this motion was filed?
Me personally, I
Anyone?
probably not. I do
Okay.
not.
So when we have disputes over compliance, the proper form to resolve those disputes is the commission and not a phone call or an email. That's how it's ordinarily handled.
No, usually there's great communication between operators and district staff, but that road goes both ways.
Did it occur in this ordinary course? Did that occur in this particular docket, this particular?
No,
matter?
Mr. Frieden hasn't reached out to me since probably January 1st.
Okay. We talked about the differing dates on the TA applications. Some say, a bunch say 12/1/2010. Some have more specific dates. When there are discrepancies in dates, is it more important to get correct information into the commission's record or to establish that one of those dates was not correct?
Well, it's always good to get accurate information. Whenever I spoke with Mr. Frieden back in July on the wells that's being revoked, you would have thought if there was any deniance in that, Mr. Frieden would have told me then that there was them wells had been produced since then.
So it's more
So-
important to have accurate information, correct?
It's always good to have accurate information. I mean,
Is the
inaccurate information.
Sorry, is the assumption always that the operator's lying and we should revert to the date that finds a violation? Is that what the assumption should be always?
No, I mean, the operator should report accurate information.
Sure,
I mean,
And
I
if
don't know
that's
if you
what's
disagree with
happened,
that.
that would be good, right?
Well, it would be helpful. Yes.
Okay. Would you, I mean, there was a question about how long Ace Energy's operated these leases. Does it sound right that the Gail Mullen lease, Ace Energy's operated since about 2015? Does that sound right to you?
Yeah, I would say that was, I mean, that's, I don't have anything that says different. Yes. I mean, I would say that was probably accurate.
And the Thornton lease into 2014, does that sound right?
I'm going to assume that all of those leases were probably purchased around the same time frame.
And the 3 wells we talked about that were plumbed for injection that we referred to earlier, are those the same 3 wells in Mr. Frieden's testimony at page 7 at the bottom that are plumbed for both production and injection?
Let me see if I can find his bottom of what page, sir?
7. The wells aren't identified there, but he references 3 wells denied for plumbed for injection, which we previously identified in your testimony as the Gail Mullen B40 and the Underwood 089 and the other Underwood 089. Those are the 3 wells.
That isn't
referenced.
what his testimony says, talking about the Thornton lease on page 7. So no, them 3 wells are not those on that lease.
26 wells. 3 of wells were unapproved because they are currently plumbed for injection purposes. I'll call up your letter again here, just so
I thought you said his testimony.
that is his testimony.
In 2016, Ace Energy re-engineered and installed entirely new underground injection electric and flow lines on the Thornton lease. And he goes
Okay.
on and so, I mean, do I have the wrong testimony?
No, I think I probably screwed it up when we were filing it, but the question is the 3 wells plumbed for injection purposes. He testifies that those 3 wells are plumbed for both injection and production purposes. It's really doesn't matter. I mean,
No, it does. It does matter if they're plumbed for injection purposes and they're not authorized. That's illegal injection.
well, if it's not injecting, it's not illegal, is it?
Though that's for a different day, I guess. I'm not sure we should go into that.
That's fine. I mean, the point is, regardless of how they're plumbed, aren't they eligible for TA status as long as they're TA'd?
Yes, and I believe I stated earlier in your question that was just one of the reasons they were revoked. The other reasons were they
Yeah.
were not, they were shut in for over 10 years.
10 years, we can file and you said we can file a 10-year TA exception application to bring it in compliance.
Yes, sir.
Yeah. One last question, because this was new to me. The requirement to report when a well is brought into production, I'm unaware of any such requirement. I know there's one for injection wells, but where does that requirement exist in commission regulations for producing wells?
I was just reading, I believe it states in that settlement agreement. Let me look at that and see what
Well, the
page
settlement
that-
agreement was signed in 2022. You're talking about that as evidence of wells that you say are shut in more than 10 years.
Yeah, sir. The operator has to, every time he does a well inventory on Kohler for his license, he has to report that his well inventory is correct. And,
Did you look at the well inventory when you decided which wells were?
I did not pull his well inventory,
Okay.
no.
I'm going to show you, speaking of K.A.R, are you aware that all 33 of those wells that you unapproved or approved that were originally approved for TA are still showing as approved for TA and K.A.R?
No,
Objection.
I'm not.
I'm not sure what evidence are we supposed to be looking at here?
Is it not displayed? I can share screen. Sorry, here's exhibit F5. I apologize. I probably should have published that letter too, but I thought I had. So this is exhibit 5. This is a screenshot of operator's K.A.R account. Not perfect, but this is what the computer screen looks like in K.A.R. I'll proffer to you that all of the wells, all 26 wells originally approved for TA that were unapproved, remain approved in K.A.R. Were you aware of that?
No, sir.
Why are they if they're not TA'd?
Don't know the answer to that.
Circling back to the requirement to report when a well is brought back into, where is that in commission regulations? I'm unaware of that regulation. This is new to me.
I do not know if it's where that's at in the regulation. The operator all the time has an open line communication. We deal with several thousands of wells and operators and are on the phone with operators every day. So I do not know that it's where it's at in the regulation, if it is.
Well, you testified it's a requirement. I don't think that's the case. Is that?
I don't think I ever said it was a requirement. I said it is a requirement in the settlement agreement because it's stated in the settlement agreement.
You mean on the quarterly reporting?
Yes.
Not prior to the settlement agreement, which was the context of that testimony.
We're at on that testimony.
We were talking about wells that have been shut in for more than 10 years, and you said there was no evidence that the operator had ever reported that the well had been brought back into production. That's not a requirement. That's not something that would be in the record.
Yeah, I said there was no evidence. I mean, the operator had never reported to the district office that the well should be changed from inactive to producing because it never had, as far as we knew, the status has not changed. And
I don't even know. I'm sorry. There's no requirement to report that, and that's why it's not in the file. If the file was consisted of everything that's not supposed to be in there, we could talk all day.
Well, the well inventory, he sure reported as inactive.
You said you didn't look at the well inventory.
I did not look at it then, but if you look at his well inventory, it shows inactive.
I don't have that, and that's a year-to-year thing, and that's not in the record. And so we can't be offering that as evidence. That's all the questions I have.
Thank you, sir.
Thank you.
Okay, Thank you. If you could pull your, there we go. All right, thank you. I'm going to look at commissioners again. Is there anything else? No. Okay. All right. Okay, folks, it's 12:35. My suggestion is we break till 1 o'clock for lunch. When we come back, Troy Russell will be the staff witness. Okay. All right. We are going to finish this today. So just know that, and we'll see you all at 1 o'clock. And please mute and stop your video if you would like, but make sure you do mute your computer. Thank you. Okay, folks, we're about 2 minutes out. Okay, looks like we've got everybody back. Well, do we have everybody, John?
Yes, it appears so.
Okay, we're all here and accounted for. All right. So our next witness is Troy Russell. Troy,
Yes, ma'am. Can John fix my nameplate on the picture?
I hope so.
Yes, I can do that.
Okay. All right. Yes, that is Troy. Troy, do you swear or affirm that the testimony you shall give today is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
Thank you. Mr. Russell, could you please state your full name for the record?
Troy Russell,
By whom and in what capacity are you employed?
Kansas Corporation Commission Conservation Division, District
What-
3 Supervisor.
What is your work address?
It is 137 West 21st Street, Chanute, Kansas 66720.
Are you the same Troy Russell who caused to be filed in this docket direct testimony consisting of 5 pages?
Yes.
Was this testimony created by you or at your direction?
Yes.
Now that you are under oath, do you have any corrections to make to your testimony?
No.
If I asked you to take the same questions contained in your testimony, would your answers be the same?
Yes.
Do you swear the answers contained in your pre-filed testimony were and are true to the best of your knowledge?
Yes.
Thank you. At this time, I move for the admission of Troy Russell's pre-filed direct testimony to the formal record.
Is there any objection? Hearing none, it is so ordered. Thank you.
Thank you. Chair Duffy, as with Mr. Dooling, Mr. Russell did not have an opportunity to submit pre-filed rebuttal testimony. May I ask him rebuttal questions at this time?
Yes, you may.
Thank you. So Mr. Russell, at the end of Mr. Dooling's testimony, there were some questions about whether operators need to let district know whether a well has been returned to service after it's been TA'd.
Objection. This is to rebut Mr. Frieden's testimony, not Mr. Dooling's testimony.
Pardon, I didn't hear that.
He's asking him to comment on Mr. Dooling's testimony in rebuttal. That's inappropriate. The opportunity to rebut is for Mr. Frieden's testimony and Mr. Frieden's testimony alone. That was agreed upon.
Chair, this.
Do you have a response?
Yes, Chair Duffy, this directly goes to the requirements of Mr. Frieden to report. And as Mr. Frieden's testimony states that he did not have any duty to report after the wells were revoked for TA status, I believe it's appropriate for Mr. Russell to.
That testimony does not exist. I don't even know what he's talking about.
Mr. Frieden's testimony states that the TA, he does not understand why those TAs were revoked because they weren't shut in for 10 years. And so Mr. Russell's testimony would go to, Mr. Russell's testimony would go to whether they were shut in or not.
No, this is completely inappropriate, and this was not agreed to. I allowed rebuttal on the fly, and now you're trying to do rebuttal on Mr. Dooling's testimony or on things that Mr. Frieden has not and did not testify to, and Mr. Frieden is present for cross-examination.
Mr. Kimbrell, your response, please.
As again, I mentioned Chair Duffy, Mr. Frieden's testimony specifically states that he has no understanding why those TA were revoked for being shut in for more than 10 years, as this goes directly to whether staff had the authority to revoke those TAs. Mr. Russell's testimony will talk about whether that is appropriate or not.
What about this? What about if you find in the testimony the discussion by Mr. Frieden regarding his comments? If it exists, we're A-okay. So if you could do that, that would be helpful.
Yes, ma'am.
Okay,
If the testimony is limited to the ability to revoke TA status, I'm okay with that.
okay, all right. So he's going to look in Mr. Frieden's testimony to see where that exists.
So Chair Duffy, on page 4, about in the middle, where it talks about, do you know which provision of the compliance agreement allows staff the ability to unapprove wells previously found to be compliant? Now that goes directly to Ace Energy's assertion that staff does not have an ability to to revoke TA applications. That again goes to, if we look up above that, where it talks about several wells were revoked for being shut in for more than 10 years.
Okay,
On the
real
top
quick,
of that page.
Mr. Schlatter, do you need us to bring that up on the screen?
I'm okay with that
Okay, all
narrow
right.
line of questioning. but
All
I
right,
would-
let's continue on. Mr. Kimbrell, you have found it for us. Proceed.
All right, thank you. Mr. Russell, do you believe that staff has authority to unapprove TA applications?
Yes,
And why is that?
if at the time after submittal, then inaccuracies are found that would present information that they should have been denied initially, then to have the correct and best information, then would have the ability to go in and revoke that TA.
And was there any information that Ace Energy submitted to you that would make you think that those wells had been shut in for less than 10 years?
No,
If those wells had actually been producing, should Ace Energy have told district that those wells were producing less than 10 years ago?
yes, it's common practice on a TA application, once approved, that if that well, at the end of the 1-year period, they will either need to file another TA, file for an exception to the 10-year TA if it's exceeded 10 years, and or notify district that they have returned it to service.
Thank you. Mr. Russell, throughout Mr. Frieden's testimony, he refers to the settlement agreement in this docket as a compliance agreement. Can you please explain the difference between a settlement agreement and a compliance agreement?
Yes. Compliance agreements are initiated at the district level when specific criteria have been met. Operator must be in good standing and show the willingness to communicate frankly with district staff. From these communications, the operator and or staff will identify compliance issues, predominantly with 82.3.111 or TA type violations. Staff will require operator to file TA applications on all the subject wells. Those wells that are denied will make up the well inventory for compliance agreement development. The wells will be assessed for potential environmental impacts, both at the surface, subsurface, and atmosphere, and prioritized for return to compliance accordingly. If the operator and staff can come to terms on the well inventory, well prioritization, and the number of objectives to be met each calendar quarter, staff will utilize the commission ordered agreement template and submit it to the operator for review. If the operator and the district agree upon that template, the operator and the district supervisor will sign it, and the signed document is then presented to legal staff for review and subsequently to the commission for approval or denial. If district staff and the operator cannot agree to terms, then the district will move forward with standard regulatory enforcement actions. The difference in the settlement agreements are that a settlement agreement is after, we've exhausted all recourse with the operator, submitted penalty recommendations. Those have been sent over to legal staff and they've been brought before the commission and a penalty order has been made. At that time, then legal staff will enter into negotiations with the operator, see if there's a possible settlement agreement. Those settlement agreements, it's generally between legal staff. Legal staff will then reach out to the district to, as far as some of the technical things to see, number of objectives that are reasonably possible, which wells are out of compliance and how best they can negotiate that agreement.
Thank you. On page 5 of Mr. Frieden's testimony, he states that revoking the TAs was quote unquote unfair to Ace Energy. What do you believe was the impact of the revoked TAs on Ace Energy?
There were inconsistencies with the shut-in dates provided by the operator when compared to previous year's applications for 20 wells and the casing information and surface control on 6 wells. These were discovered by the district compliance officer, Ron Dooling, during review of the TA applications. Based on those findings, district would have revoked those TAs for any operator within the district. The fact that they were discovered prior to the July 31st, 2022 deadline outlined in the settlement agreement was of significant benefit to the operator. Normally, each of these violations would have generated a 30-day NOV letter to the operator requiring them to obtain an acceptable TA, return to service, or plug the well within 30 days. Since they were added to the agreement in which the operator is only required to return 5 wells per calendar quarter to compliance, which is approximately 2 years for the 38 wells. They got that length of time instead of 30 days.
Thank you. On page 5 of Mr. Frieden's testimony, he states that a CIT costs approximately $1,500 per well. Can you just briefly give an explanation of what a CIT is?
CIT is a casing integrity test. All of these CITs for these wells would be fluid depression. It is where operator or contractor will hook equipment to that wellhead and pressure it up either to an air compressor or nitrogen bottle to a calculated pressure that's determined by the fluid level and the depth of the well or 50 foot above the perfs. And then if that holds that pressure for a length of time, then it passes. If it does not, then it will fail.
In District 3, does a CIT normally cost $1,500?
No, common, what generally we find of what we've been told and stuff is that probably between $300 and $400.
And so far, how many of Ace Energy's wells have passed CITs?
10.
On Mr. Frieden's testimony on page 7, he states that the requirement that Ace Energy notify staff in writing when wells are returned to service is a formality. Do you consider that such notification to be a mere formality?
No. Notification is really critical. Get my notes here because the critical parts of the compliance agreement when we negotiate that is that there's just in summary 4 things. First, it's a commission order and staff or the operator cannot change or amend it without a commission order. The language within all agreements that allows conservation staff to identify any well that now has been identified as posing a greater environmental threat to be moved up on the prioritization list immediately and to be brought into compliance in a very short time. Third is the ability of staff to recommend to the commission with operators' consent to amend additional wells to the agreement. About 100% of the time that request comes from the operator. And then the requirement of the operator to notify district staff in writing when the subject well has been returned to service is absolutely important for the use of staff's time and responsibilities to go check the status of these wells. Any operator in a compliance agreement or settlement agreement that reports to us that they have returned a well to service, staff will go and determine if that well has been returned to service. Based on the past record and operating history, if we've had problems with that, we go, because we want to just make one trip. And at this point in time, it's already ordered. The overwhelming majority of operators know what return to service is and what requirements will be. So if staff goes at the deadline, we'll do that in one trip. The well is either in or out of compliance because we have to make a report to legal staff within the first week after each calendar quarter of whether the compliance objectives were met.
And did you do that for the December 31st, 2022 deadline?
Yes,
What date did staff go out?
January 3rd, I believe, on that field report, and part of Ryan's testimony was the first field report to check statuses of wells that had been called in.
Yeah, thank you. Kind of piggybacking on that, on page 7 of Mr. Freed's testimony, he states that it's unreasonable for staff to conduct field inspections to make sure wells are in compliance before they're considered to fulfill the quarterly requirements. Do you believe such field inspections are necessary in this docket?
Yes,
And why is that?
for several reasons, because we've got, we've been contacted in writing of certain wells that have been returned to service, particularly returned to service. And then when staff has went to the field to inspect that and to get the status of that well, they're not even pump jacks. There's no equipment on those wells. They're open. They are not returned to service. And if that's the kind of information that we're going to receive, then we have to have our due diligence to verify that.
On page 8 of Mr. Freed's testimony, he states that the wells that have passed the CIT should be granted TA status. So just because a well's passed the CIT, does that mean that the well is automatically going to be granted TA status?
No,
And why not?
there are other factors that consider into that. One, do they have surface control on that well? Do they have a valid lease? One of the more important thing is, has that been shut in for a period longer than 10 years? Then they're on the right track. They need to file for an exception to the 10-year rule to get that TA, which the CIT would be a part of.
On page 8 of Mr. Freed's testimony, he states that staff is making it inordinately difficult for ACE Energy to come into compliance with the settlement agreement. How many settlement agreements are currently active in District 3?
Approximately 25.
And
I'm sorry, settlement agreements about 6.
6, okay. In the past, how often do settlement agreements end up in hearings before the commission?
We've had one. This is the first settlement agreement and one compliance agreement.
Do you believe staff is making it inordinately difficult for ACE Energy to come into compliance?
No,
And why not?
because, the field staff and operators staff are in communication. We're more than willing, if we're asked questions, to comply with whatever help we can. We would share information. We'd gladly provide a list if we were asked. The denied TA should have been readily available. We sent copies to them, direct emails. We have lots of conversation. Ryan has reached out to help them make sure they remember important deadlines as far as the filing of those TAs mentioned in Mr. Dooling's reference. Staff is most of these wells, staff has GPS these leases. Staff has provided the matching up and the information for them, to help them know what their inventory is, help them what to have to do that time, spend that time doing those, so that they have those, we share those GPS maps with them. And I think every one of these have been GPS by district staff.
Has District 3 staff treated Ace Energy any differently than any other operators with settlement agreements in District 3?
No,
If the commission finds that Ace Energy has not met its deadline and suspends Ace Energy's license, do you believe that Ace Energy's license should remain suspended until it's brought all the wells into compliance?
yes, I think they should adhere to that settlement agreement order, and that should be suspended until such time.
Thank you. I have no further questions.
Okay, thank you. Mr. Schlatter, your turn.
Chair Duffy. Mr. Russell, you were testifying about the differences between a compliance agreement and a settlement agreement. You were reading from something. Was that a policy that you were reading from?
No, that's just my notes, because I figured I would be asked that.
Your what?
Notes, my notes. Just
Your
notes I
that script
typed up.
was your notes?
Mhm.
Is that the same thing? You also talked about the discrepancy in the dates and the TAs and how that was such a good deal for Ace Energy to have all those wells unapproved and now have to have a CIT. That was your notes as well? You were reading
Yes, sir.
something.
No, I would be happy to give you a copy of my notes. I mean,
I thought you were reading a policy. When did you
No.
prepare these notes?
when last night,
Okay. And then the same thing with the amending of the settlement agreement. You went down 3 different factors. You were reading from a script. That was something.
that's something just to help me to remember and pull up without having to go to the commission order template is readily available.
Okay, so you prepared your testimony last night.
No, that was notes I had before, because they told us we wouldn't have we would do rebuttal here today without filing a chance to file rebuttal.
Right, and that was my understanding as well. I just didn't know it was already going to be prepared. I would have liked to have that. The CIT, you mentioned you know how much a CIT costs. How many CITs have you paid for in your career?
0.
Okay. Have you been you mentioned some things you observed in the field. Have you been on these leases before?
I've been on some of these leases, but it's been quite some time since I've been on them.
So not recently,
No, I have not.
not since the settlement agreement's been signed.
No,
And you mentioned also communications with Ace Energy between District 3. Have you communicated directly with Ace Energy at all since the settlement agreement?
I think I've only maybe exchanged an email or two, maybe with
One or two.
Mr. Badeau and then, but they have not reached out to me.
Okay, so all of that testimony, none of that was true then.
Objection.
I disagree.
Well, how do you know what was going on in the field if you've never been in the field?
Because I talk with my field staff and they
It was
operate
hearsay.
under my direction. No,
Why
it's
didn't you-
documented in field reports.
Okay, those field reports are in the record?
They can be.
You have your testimony in front of you.
Yes, sir.
I have a question, and this is a curious question. It's not, I just want to know, what is the purpose of your testimony on page 4, beginning at line 6 and ending on line 17 about what an injection well is, in the context of this docket, I should say. I read that and I said, I mean, we know what an injection well is. I'm wondering what was the point of this testimony?
To differentiate between whether the wells, subject wells, should be considered as return to service.
Okay, and why are we talking about that?
because they claimed that they had returned those wells to service.
Are you referring to, is that the email that's attached as exhibit RD2?
I'm referring to-
testimony?
I'm referring to the Thornton J9, J1, the Thornton K9, C67, the Thornton L9, 65, and the Thornton L11, J9.
You're saying they
That
weren't-
were ruled that they, I believe those were the wells that they had determined had been brought back into service back in November.
before Thornton wells. So I guess what I thought was that you were saying that a well, and this is why I'm asking the question, that a well has to be plumbed for injection to be eligible for TA status. That's not your testimony, is it?
No,
Okay,
That's
so
not.
TA applications could be filed for these wells and they could be brought into compliance that way?
yes, they could, if
Okay,
they met all the criteria.
all the criteria that you already visited.
Yes.
Okay, I caught a word in your testimony, caught my ear about having to bring all of the wells into compliance. Is it your understanding that the compliance agreement, if Ace Energy gets behind, that it is, and any of these quarterly deadlines, that it immediately has to bring all of the wells into compliance, or it just needs to catch up with compliance? For example, if it brought 4 into compliance before the end of this month, it would be caught up on in the fourth quarter.
Mr. Myers, can you pull that agreement up? But I believe that's an order. I cannot change it or alter it without commission approval. And the order says if they miss an objective, then they will be suspended until all the wells on the agreement are returned to compliance or brought into compliance.
That's fine. I'm just wondering what your position is. I was under the impression that if Ace Energy got behind, they could merely catch up. You're saying once you
don't.
fall out of compliance, you're done. You got how many days to bring them in compliance? 30, you said?
No. If they do not meet this settlement agreement's objectives, their license is suspended until they bring all the wells on the settlement agreement into compliance. And remain the wells that were denied on the 29th of July, if they would not have been included on the settlement agreement, those 26 wells would have each generated an NOV automatically, and they would have had 30 days to bring all of them into compliance.
So when you read the agreement to mean bring all the wells into compliance, not the company to bring itself into compliance under the agreement.
On the agreement, my understanding is those wells on that agreement,
All of the wells.
on that agreement.
So it's not a matter of Ace Energy. If you say they need to bring 4 into compliance by the end of the fourth quarter because there's a dispute there, they'd bring 4 into compliance. You're saying that's not good enough. It's got to be all 45.
I'm not saying that, the agreement's saying that.
Well, it's an awfully literal reading of that agreement, which I find curious considering your position regarding the ability to unapprove previously TA'd applications.
If
Can you explain why
those-
that should be read into the agreement, but we should take the obligation, or really draconian outcome against Ace Energy on the one hand, but just add whatever staff wants into the agreement to sort of whitewash its conduct?
No, that agreement listed that staff would to make the determination on the wells that would be denied by July 31st. That determination was made by July 29th.
What says shall approve or deny, and 26 of those were approved. Doesn't say approve and deny. And if we're going to take the most literal interpretation of that agreement, that's not allowed, right?
I don't agree. It said by the 31st, which is what we did. Because we had ECRS overlook something on a application that was incorrect, does not make it right. And if we caught that in a timely manner, which we did, then that's the position.
You have no firsthand knowledge that that's incorrect. Your diligence was the same as Mr. Dooling's. You looked at an old form.
I'm basing it off multiple forms that have been filed by the operator, not just TAs, but other correspondence that we've found discrepancies in.
But has any effort been made to find out what the actual correct date is? Or are we just going to pick the one that's has the most adverse consequence?
No, we have looked through, why file multiple TA forms with the incorrect date, and then when the 10-year period comes up, conveniently change that.
Did you ask
I've
Mr.
not been presented
Cleveland?
with it. Maybe he will present something to us today to show us different.
I hope he has that opportunity, but I'm wondering why nobody asked him that question before we got into a trial. What, did you ask him?
No, I did not. And the fact is, they've only returned 6 wells to compliance, and 10 was the deadline. Shortly, it'll be 15.
You also mentioned a requirement to report when a well is returned to service. I mean, and that was outside the context of the settlement agreement. Or where is that regulation?
It is not a regulation, it's just standard procedure. Overwhelmingly, operators do that. That's one way we know at the end of that year what the status of that well is if they do not produce it.
In District 3, the standard practice is to report every time a well is put into production.
If it has previously been PA'd recently, yes,
How many TA wells are there in District 3?
probably close to 2,000.
And so you get 2,000 reports every time one of those wells is brought into production?
We get a simple email or phone call, or they contact field staff.
I talked with Mr. Dooling. I assume you were present when that testimony was occurring about 15 wells that could merely, paperwork type of stuff could be filed to bring those wells into compliance. Would that solve a lot of the problems that we're visiting about today?
I think that they're, here today is because deadlines weren't made to bring them into compliance in the future. I think there are opportunities to pursue the 10-year exception on some of those TAs, on the ones that we believe have been past that 10-year date.
And provided they pass a CIT, if we filed those applications next week or sometime, could ostensibly catch up.
Ostensibly, hypothetically.
And would staff wouldn't object to those, would they? Unless there was some specific reason why.
No, staff, if it has an approved TA, unless something else was brought to our knowledge as far as having the lease or something like that, it would go through that process, normal process before the commission. Staff does not make that decision on a 10-year exception.
Okay. But, I guess where I'm kind of getting back to is our objective here is to get these wells into compliance. And I think part of today is to figure out, there's clearly a dispute as to which wells are and are not in compliance, but isn't that District 3's goal under the settlement agreement? Ace Energy's goal is we want to get these wells into compliance.
Well, but that needs to go both ways. When we get written notification that specific wells have been returned to service, put back into production, and we go out and find what we find, we got to go by those deadlines. That's why we're here today. Those attempts were made a number of times prior to even getting to the penalty recommendations.
So everybody's on the same page. We're trying to get these wells into compliance.
The commission would like for these wells to be into compliance.
Thank you. One question I'd ask, this is it. I'd ask Mr. Dooling about what was the point of the 45 initial TA applications? Where did that come out of, particularly if 38 of them were going to ultimately be either denied or unapproved or revoked or whatever the word is we're using today? What was your understanding of what the status of those 45 were at the time this agreement was entered into?
Those wells, I believe, are part of a consolidated docket that brought those 45 wells into the penalty agreement and created the settlement agreement. The purpose of filing those was so that all the simple paperwork TAs that would be exempted could be done and excluded from the agreement. So we only focused on those wells that needed attention,
And
that were out of compliance.
So you had no idea if it was going to be 3, like Mr.
No.
Frieden thought, or 38, or whatever it was on July 12th. You didn't know what that was going to be.
We did not know what the well inventory of this compliance agreement would be until July 31st.
That's all the questions I have.
Okay, thank you, Mr. Schlatter. Commissioner questions, and I'll start with Commissioner King.
Thank you. Good afternoon, Mr. Russell.
Morning, Commissioner King, or afternoon.
Tell me a little bit about yourself. How long have you served as the director of the KCC District 3 office?
I've been district supervisor since 2017. Worked in the district office since 1997.
And what did you do in the earlier years with the district office?
I was what they at that time called the remediation geologist, or the district geologist.
Okay. Are you a licensed professional geologist?
Yes, sir.
How long have you been licensed as a professional geologist?
Since I think 1993 or 94.
Okay. One question I want to ask you, I asked of Mr. Dooling. I'd like your take on it as the district director, given your experience. Under settlement agreements or compliance agreements between operators and the KCC staff, which of these parties, in your opinion, has the obligation or burden to comply by taking affirmative steps that are set out in the agreements?
The operator,
And why is that?
because the agreement is made to benefit them, so to speak. Settlement agreements, I don't want to call them a last chance, but they set down very definitive goals and objectives that need to be made. And it has been through a hearing review. So at that point in time, it behooves them to stay on top of these and to take full advantage of them.
Let's talk about that benefit to which you just alluded. What is the trade-off, Mr. Russell, or the benefit, if you will, that accrues to an operator by using either a compliance or settlement agreements?
It allows them time to and I know Mr. Slayer don't like, but I like to go back to my notes that I did make notes here. But is a successful compliance agreement is a valuable tool for industry and conservation staff. It allows resources to be directly utilized by both parties to address compliance issues in a timely manner, mitigating environmental impacts, as well as providing operations flexibility to industry. Particularly, it can provide industry a tool to also assess potential acquisitions of additional properties that may require substantial investment in infrastructure that currently pose minimal environmental risk or may already be part of or a result of an existing commission enforcement action. Due to the significant staffing resources, it saves both parties time. It allows them to plan, and if it's a simple infrastructure issue, they can get that infrastructure in place while they bring those wells online or get them back into, or basically they assess them. They decide what they want to keep or what they want to plug. And it gives them some time frame to do that, while at the same time we are monitoring any potential environmental impacts. And we have the ability in those agreements that if we have a concern comes up, that we can move that well right to the top and get it taken care of. So it saves us from a lot of hearings.
Let me kind of boil that down, put it in my own terms, and then you tell me and correct me where I'm wrong. Is not a major feature of these settlement and compliance agreements the trade-off that it gives the operator? It's mainly time. It's mainly time and money to the operator, because the operator is being given the benefit of time of time to perform certain activities, whether it's bringing the wells back into production, whether it's having the wells plugged. They're given the benefit of time, whereas in the absence of a compliance agreement, the literal reading, the black letter reading of the reg and the statute would not provide that kind of time frame. Is that not correct?
Yes, it is very correct, sir.
I know that in his testimony, Mr. Dooling indicated that there were several wells under the control of the operator that lacked surface control. What risks accrue from the absence of surface control to the environment?
The potential risks are, of course, produced fluids migrating upward and out onto the surface, and possibly, the waste or venting of gas.
Okay. Let's go back to this matter of the discrepancy, this date discrepancies, which has been discussed here rather extensively. When you have ongoing filings or the reporting of TA status on an individual well, is it unusual that there is a variance in the initial shut-in dates on different applications on the same well?
Not on consecutive years. I mean, if a well was shut in and TA'd for, say, 2 years and then put back in production for a period of 2 to 3 years, and then they TA'd it again on that 6th year, that 6th year would be the new shut-in date.
Okay. Let me go back just very briefly, just to put some closure to this in my own mind here on this question about why with 45 individual wells did you have individual TA applications? If I look at this from about 30,000 feet, the reason I would guess is because each individual well potentially poses an environmental risk. And each individual well deserves an individual treatment, basically an individual treatment that provides for a tracing mechanism. Does that make sense?
Yes, sir.
John, if you would bring up for me, let's go to the settlement agreement. It's page 5, the same page I believe Mr. Slatter asked you to bring up previously.
One moment.
It's a subparagraph H. Yes, that's it. Yeah, that's fine. Can you see this, Mr. Russell?
Yes, sir.
Okay. We don't make our task easy here because we don't have numbered lines, but if you'll go down roughly halfway, keep your eyes focused, if you would, on the left-hand margin, go down to the sentence that begins with the word failure.
Okay.
Let me read that sentence. It says, failure to timely bring the subject wells into compliance by the appropriate deadlines or to pay the penalties by the appropriate deadlines shall result in suspension of operator's license. Mr. Russell, what does that mean to you?
Means if they miss one of the quarterly deadlines, their license will be suspended until all the wells on this agreement are brought into compliance.
All of the wells. Correct?
Yes.
Yeah. Mr. Russell, I appreciate your responses to my questions. I have no further questions of this witness.
Thank you, Commissioner King. Commissioner French.
No questions for Mr. Russell. Thank you.
Okay, Mr. Russell, so let me understand this. On a compliance agreement or a settlement agreement, is the operator already out of compliance? I mean,
Yes.
so they're out of compliance. They have either violated a statute or a regulation or rule, correct?
Yes.
Okay. I appreciate Commissioner Keen bringing forth the settlement agreement. I think that's really a new feature since I've been back, that we have these settlement agreements and compliance agreements. I think was very rare before, but the next sentence allowed that staff may prioritize the order in which the subject wells are addressed pursuant to this agreement and may adjust the prioritization at any time during this agreement. And this is staff. Should the subject well become known to staff to be a pollution or public safety threat. Other than that, I'm not seeing where you have any other like authority to change this agreement. Is that correct?
I have no authority to change this agreement except for that. I mean, the two wells that failed the
Right.
CIT, they should be taken care of immediately.
Okay. All right. So at that point, then your recourse is to come back to the commission. Is that correct?
Yes, ma'am.
Okay. All right. I believe that's all the questions I have for you. Thank you, Mr. Russell. Now I'll turn back to redirect Mr. Kimbrell.
Thank you. Just very briefly. So Mr. Russell, I believe Mr. Schlatter suggested that by revoking the TAs, you are adding something in to the settlement agreement. Is revoking TAs something that can only be done in the settlement agreement?
No.
So you could revoke TAs if there's false information filed on a TA from any operator?
Yes.
So this is kind of a general authority that district staff has, is that correct?
Yes.
Just in general, if an operator's license is suspended, in your experience, does that make them work more quickly to come into compliance with commission regulations?
Yes.
So suspending a license tends to make operators work more quickly to come into compliance?
Yes, it does. It improves communications drastically.
All right, thank you. I have no further questions.
Thank you. Mr. Schlatter.
Yeah, thank you, Chair Duffy. This authority to revoke TAs, were you present when we put Exhibit F5 up showing that none of them have been revoked? None of the wells
Yes.
have been used.
And I would like to expound on that if you would like me to answer that, or did you have a question?
I asked if you were present when that exhibit was published.
Yes, I'm
Sounds
sorry.
like the answer is yes. Yeah, go ahead. I'm really confused. It's not in the agreement. Like the requirement to report when a well is put back into production, I'm entirely unaware of this authority to unrevoke. I'm getting tired of hearing about lying because that's a new position today, as far as I know. But if you'd like to expand on what that means and how that happens, I'm all ears.
Well, and it does not happen often. When a TA is revoked and or put back into denied status, that TA has to be done on a hard copy. The operator is sent the updated copy and notified of what has happened, which was done, and then those hard copies have to come to the central office where they go through the process of being scanned and entered into the well document imaging history on RBDMS, which is where Kohler will get that information. So I'm not surprised they are not showing up on Kohler yet at this time as denied.
I I'm sorry, I didn't follow that. You said that there was hard documents that were sent to,
No, when those TAs were revoked and put back into denied status, those forms have to be printed out hard copy. They are denied. The reason why, there are copies sent to the operator showing them what has happened, what has occurred, and then those copies are submitted to the central office where they will be included into that well document image history, which is where Kohler will then make them available. So that appears not to have occurred at this time yet.
that was gonna be my next question. It doesn't sound like that actually happened.
I think it's probably in the process, but that process of sending hard copies here to be scanned and put in the images.
Can we call up the compliance agreement real quick? I was also confused by some testimony just a minute ago.
Yes, one moment.
You mean the settlement agreement?
Yeah, did I call it the wrong thing again?
You called it a compliance agreement.
Yeah, I was, sorry.
That's all right. All right, just want to make sure.
I haven't promised to call it a settlement agreement throughout at the beginning of Mr. Dooling's testimony, so I apologize.
That's all right.
So, and I'm not driving here, but we looked at that sentence, failure to timely bring the subject wells into compliance by the appropriate deadlines or pay the penalties shall result in suspension of operator's license. Well, we established in Mr. Dooling's testimony that Ace Energy paid all the penalties by the appropriate deadline. Were you present for that?
Yes,
So failure to bring the subject wells into compliance by the appropriate deadlines, the only way I can construe that is if he didn't file all 45 TAs, that would be a breach of that provision, correct?
he had to do that by July 1st.
Right, and we already established that happened.
Yes,
And the other would be the appropriate deadlines would be the 5 wells per quarter.
yes,
Correct.
5 wells per quarter.
So that result in his license being, so where do we get all wells out of that sentence? Have to be brought into compliance to achieve a deadline. That's not the agreement.
I don't get that out of that sentence. I get
Oh,
it out of the sentence
I
that
would-
says it will remain suspended until all the wells are brought into compliance on down that paragraph.
Okay, I thought you said that sentence said that. I was confused. That is my mistake. I think that's all I have for you, Mr. Russell.
Very, very good. I'm going to look at commissioners again. Is there any follow-up questions you have? No on Commissioner Keen, no on Commissioner French. Okay, it looks like Mr. Russell, you can virtually step down. Thank you.
John, can you shut us down on your end or do I have to?
It would be best if you did it, I think.
Okay, it appears we're ready for the operator's witness, Mr. Schlatter.
Yeah, I would like to call Mr. Johnson.
Okay, I cannot hear you.
Can you hear me now?
Yes, you're turned toward the camera. I think just that little movement, we couldn't hear what you were saying. All right.
That was a commercial. Can you hear me now?
Yes,
Let me find his testimony. Okay, yeah, I would like to call Mr. Jonathan Frieden of Ace Energy.
okay, Mr.
Yep.
Freed. Yes, there you are. And
I'm here.
okay, if you'd raise your right hand, do you swear or affirm that the testimony you shall give today shall be the truth, the whole truth, and nothing but the truth?
Yes,
Thank you.
yes,
And
ma'am.
Mr. Frieden, yesterday we had this technical difficulty, but if you could remove your
Yeah.
earphones,
Mhm.
I think we could hear you clear.
Okay,
I did do what I was told, Mr. Myers. I practiced on Zoom.
Thank you, Mr. Schlatter.
You're welcome.
Every time we do this, we're practicing on Zoom, so you know.
It's always, you never want anyone watching you practice too much. Okay, let's see. Can you please state your name and address for the record, Mr. Frieden?
Can you hear us, Mr. Frieden? Okay, we can't hear him.
We did fix this one yesterday. Um,
Oh, there,
There we go.
Okay,
there.
okay. Could you please state your name for the record, Mr. Frieden?
Jonathan Frieden.
And for whom are you testifying in this proceeding, and what capacity?
I'm testifying on behalf of Ace Energy.
And your title there?
My title is the general manager owner.
And did you cause testimony of 8 pages of questions and answers and exhibits identified as F5 through F3 to be pre-filed in this docket?
Correct.
And do you have any corrections to this testimony?
I don't think so, no.
So if these questions and answers were asked of you today, the questions were asked of you again today, the answers would be the same.
Yeah, unless there was some, yes, I'm almost positive, yeah.
I move for the admission of the pre-filed testimony of Jonathan Frieden be spread on the record in these proceedings.
Is there any objection?
No
Hearing
objection.
none. Pardon?
I'm sorry, no objection.
Hearing none, it's so ordered. Thank you.
I have two things before I tender this witness. One is a housekeeping thing that I just recognized. I've offered exhibits F5 and F4 into the record. Can we show those as admitted as well?
Any objection?
No objection.
It's so ordered as well.
And then during opening was the first time I personally heard that there was going to be testimony that false documents were filed in this case. This was a civil trial. That would be grounds for a mistrial. Moreover, this is being publicly televised, as I understand it. And so the only thing I would ask is if Mr. Frieden's going to be given an opportunity to explain the discrepancy in the TA dates, which is the source of that allegation, then I don't need to do any additional rebuttal testimony, if you will. But if he's not, I'd like to have that option at the conclusion of this hearing, or of his cross-examination, I should say.
We'll allow you some latitude there, Mr. Schlatter. Yes.
And that's, if he handles it in cross, I don't need to do it. And if he doesn't, I'd like that opportunity.
That is fine.
Okay, thank you. I would submit this witness for cross-examination.
Okay, thank you. Mr. Kimbrell.
Thank you. Mr. Myers, if we could bring up exhibit RD3.
One moment.
Thank you. Mr. Frieden,
Mm-hmm.
there we go. Is this an email you sent to KCC staff on December 27th, 2022?
If I can see it, let me get my December 22nd,
27th.
27th, Thornton K9. Yes.
And in this email, do you indicate that 4 of the Thornton wells are in compliance with the settlement agreement?
4 of the Thornton wells are in compliance with the settlement agreement. Yes, compliance. Yes.
And do you also indicate that the Gale Mullen C43 and Gale Mullen I43 are in compliance with the agreement?
Those are the listed wells. Yes.
Thank you. Mr. Myers, if we could go down to the next page, RD4. And Mr. Frieden, is this an email you sent to KCC staff on December 30th, 2022?
Yes, yes.
And at the top, does it say KCC staff? The Gale Mullen F41 has passed CIT. It's fully equipped and pumping as of 12/30/2022. Field staff has been in regular contact with my team and has visually inspected the well without any issues. Therefore, we have met the terms of bringing 5 wells into compliance prior to the 12/31/2022 deadline. Did I read that correctly?
That is what's written there. Yeah.
All right, thank you. Mr. Myers, if we can go down to exhibit RD5, page 7. Mr. Frieden, is this a picture of the Gale Mullen F41 taken on January 3rd, 2023?
I don't know if that specifically, again, I didn't take that picture and the numbers sometimes, if that's what you're saying, then yes.
Do you have any reason to doubt that that's a picture of the F40, the Gale
I
Mullen
don't
F41?
have a reason to doubt, no.
Okay. On January 3rd, was the well in this picture fully equipped and pumping?
That, if that's the F41, again, there were, yeah, I'm going to answer your question, and if that specific well, is that what you said?
Yes, that specific well, the Gale Mullen F41, is that well equipped and pumping?
That specific well is not pumping. No.
And that's the well that you referred to in the email that I read, that you said was fully equipped and pumping. Is that correct?
But I do know that we swapped a well out that your staff was aware of.
I'm asking about the email that you sent on December 27th. Sorry, it's December 30th, saying that the Gale Mullen F41 was fully equipped and pumping. Is that well fully equipped and pumping?
I made a mistake on the well number, obviously, but yes, that's the well that I said, but I'm saying that that's a mistake on the well number. There's 3 wells there that are all lined up, and I wasn't there. So I'm going to say that was a mistake in the email. Yes, but I admit that there were 3 wells that the guys were working on with your staff, and they made a site decision that I think you're aware of. And
Mr. Frieden, that was my question.
Okay.
My question is whether it was fully equipped and pumping. Thank you. Has this well been plugged on January 3rd, 2023?
Has that well been plugged? I think that well has a jack on it right now and is pumping. I think. I'm
Mr.
not.
Frieden,
Yes.
that wasn't my question. On January 3rd, was this well plugged?
On January 3rd, was that well plugged? No.
On January 3rd, 2023, was this well TA'd?
Was that well TA'd? I think it passed a CIT prior to that.
But it wasn't TA'd.
Did it need to be TA'd?
Mr. Frieden, on January 3rd, 2023, was this well in compliance with the settlement agreement?
It passed a CIT and yes, to my understanding of the settlement agreement, yes.
Mr. Frieden, you just testified that the well wasn't plugged, that the well wasn't producing, and that the well wasn't TA'd. So was the well in compliance with the settlement agreement?
The well passed CIT, and I submitted 6 wells for the compliance agreement. Yes.
Does the compliance agreement say that all you have to do is pass a CIT in order for a well to be in compliance?
Yes.
Sorry, the settlement agreement. Does the settlement agreement say that?
Yes, I think it does. I'm not a lawyer, but I think that, and that's why we're here. That's what we've been talking about. Yes, that the CIT. I submitted six, anyway, okay, I mean, can I answer you anyway?
All right, we'll get to the settlement agreements. And Mr. Myers, if we could go to RD5, page 6. Is this a picture of the Gale Mullen C43 well taken on January 3rd, 2023?
Are you asking me?
Yes, Mr. Frieden.
If that's what you're saying, I wasn't there.
Do you have any reason to doubt that that's a picture of this Gale Mullen C43?
The Gale Mullen C43. I don't see a day. Okay, that's. If
On
that's what
January
you're
3rd.
saying, yes, if that's what you're saying.
Thank you. On January 3rd, was this well fully equipped and pumping?
My staff told me that the Mullen wells were fully equipped and pumping, the wells that were out there. So I don't know. I wasn't out there. So to my knowledge, there were 2 wells out there, and then your staff was out there as well. I don't know about these pictures, but to my knowledge, there were one well that would have added to the 4 wells on the Thornton. I don't know which one well, but there was one well out there that was equipped. Obviously not this one.
Thank you. And on January 3rd, this well had not been plugged. Is that correct?
No, not been plugged. No.
January 3rd, 2023. This well in this picture, was this well in compliance with the settlement agreement?
It passed the CIT.
All right, we'll get to that, to the settlement agreements in a second. If we go down to, or sorry, go up to page 4. Let's see page, okay. Is this a picture of the Gale Mullen I-43 well taken on January 3rd, 2023?
Yeah. Mhm.
And on January 3rd, was this well fully equipped and pumping?
That would have been the well, to my knowledge, from what my staff told me, was the one that was counted towards the that's the one that they said that they were working with staff on. Yes, I think. Yes.
And on January 3rd, this well had no motor. Is that correct?
I can't see in the picture, but I was told by my team that staff told them that this was compliant.
On January 3rd, this well was unplugged. Is that correct?
Unplugged. The well was not plugged. No.
Well was not plugged. And on January 3rd, 2023, this well was not in compliance with settlement agreement. Is that correct?
Staff told my team that it was compliant.
Who on staff told your team?
Brad.
Brad who?
Brad Boehner, because he had been out there working with my team.
And do you have any emails from Mr. Boehner indicating that?
Yeah, I have some communication, and January 3rd is after the compliant date, by the way. So,
Mr. Frieden, if the well was supposed to be returned to service by December 31st, 2022, and on January 3rd, it wasn't returned to service, doesn't that mean that it missed the deadline?
Brad was out there with my team between the emails that you had sent to us that we were working, as you know, because you had told us, you told me that there were 2 wells that had issues, no other wells except, I think it was 2 Mullen wells, and they were working over the weekend and they were in constant communication with Brad. And he was the one that told them. And then I was communicated that that well was going to be fine.
And what date are you saying?
Prior to the deadline. It was over that. Again, I don't know the days of the week, but they were out there all weekend before the deadline based on your feedback to us. So we were working feverishly with Brad, the staff member, based on your feedback to us.
So you're saying it was at the end of December, that last week of December? is
Prior
when-
to the deadline, correct?
Okay, so between this last week of December and January 3rd, did someone from Ace Energy go out and remove the motor and remove the bridle?
Remove the motor, there was, all I know is that there was a motor and Brad was out there and my team was out there and it was, yes, there was a motor and yes, I don't know after January 3rd, but I do know that all I can speak to is up to the deadline and what I was told by Brad, what my team, Brad and the 3 people out there, I was communicated that we were fine.
All right, Mr. Mars, if we could go to, let's see, exhibit RD6, page 4. Thank you. Mr. Frieden, is this a picture of the Thornton K9 C67 well on the Thornton lease taken on January 3rd, 2023?
If that's what you're saying, yes, if that's what you're saying.
On January 3rd, did this well have no surface control?
Again, I'm not an expert, but per my testimony, I can't, it looks like it does have surface control. It's an injector. So I do see there's valves there.
On
So
the, sorry, go ahead.
if that's an injector, I'm not, I can't see it very well, but it looks like it does have, and those were previously approved on the November, as in my testimony, but it, and we weren't notified, and you didn't tell us that there were any problems prior to our deadline on those, so.
Mr. Frieden, on January 3rd, was this well taking any water?
Was it taking any water? I'm not aware.
So was this well returned to service?
I don't know if taking water and this is returned to service. It was compliant.
Mr. Frieden, if the well wasn't taking water and it didn't have any surface control, how was it compliant?
Because it passed and it was compliant. It was, I don't know if, hold on a second. Again, I'm not a KCC lawyer, but we were told by your staff on staff inspection that everything was compliant. Again, that's why we were, yeah, I mean, to me, I don't, again, I would disagree in my testimony. I said it was compliant. So I disagree with you.
You keep saying that staff told you that this was compliant, that all these wells were compliant. When were you told this by staff?
We had a staff, it's in my testimony. We had called in for an inspection on when our license was, I think it's in my, I'm pretty sure it's in my testimony. We called in for an inspection when our license was turned on to verify that the remaining 4 injectors were compliant. We didn't say that they were, I mean, there's varying definitions of compliant. And then during that visit, because we were working feverishly to get all of our wells compliant and all the remaining injectors were approved on that date.
And which date is this?
That was called into the district office and that was approved.
By phone, by email? How's this approved?
By Levi, and then your email back to us, you made no mention of any, when we sent in, you mentioned no, the only 2 wells that you had an issue with were the Mullen and the 2 Mullen wells that I submitted of the 6 wells that I submitted. But yeah, we did call in for an inspection and Levi did approve the remaining, the 1 well the commission And it's in my testimony. I don't know where it is, but I did put it in there. And that record should be with the district office in terms of the call-in for the inspection.
Yeah. Do you have any email or any kind of documentation
Like
indicating
I
that?
said, the call-in for the inspection and Levi's report.
Okay, Mr. Myers, if we could go to RD6, page 6. Mr. Frieden, is this a picture of the Thornton L9 C65 well taken on January 3rd?
The L9. Again, I can't see that. If that's what it says it is, yeah.
Was this well shut in with a ball valve on January 3rd?
I can't see that, but it looks like it is.
Was this well taking any water on January 3rd?
I'm not aware. I can't tell in that picture.
So was this well out of compliance with the settlement agreement on January 3rd?
As my statement says, it was in compliance.
All right, Mr. Myers, if we could go to page 8. Is this a picture of the Thornton J9J1 well taken on January 3rd? Mr. Frieden?
If that's what it says it is, yeah.
And on January 3rd, was this well shut in with a ball valve?
Is that a injector? I can't see.
It's one of the Thornton injection wells, yes.
Is it shut in with a if it was inspected on the 4th and we were told it was compliant to mine, and that's what I said in my testimony, it was compliant. Yeah.
Thank you. On January 3rd, was this well taking any water?
Again, I'm not aware of that. To my knowledge, I don't know.
Thank you. And then finally, Mr. Myers, if we could go down to page 8.
Mr. Kimbrell, I believe that was page 8 of RD6.
Oh, sorry, I meant page 10.
Very good. Hold on.
And Mr. Frieden, is this a picture of the Thornton L11J9 well taken on January 3rd?
Okay. Yeah.
And on January 3rd, was this well shut in with a ball valve?
I can't tell in that picture.
January 3rd, was this well taking any water?
Again, in my testimony, these wells all had approved TAs. So once again, yes, they were compliant.
All right. So, Mr. Frieden,
So
did you?
regardless of whether they're taking in water or not, I don't know what you're getting at, but I'm unaware whether they're taking water or not.
Mr. Frieden, you stated in that email that all of these wells were in compliance.
Compliance with KCC regulations because they were TA compliant, yes, even before going in this agreement, yes.
And did you receive the letter from Mr. Dooling indicating that the TA compliance had been revoked for several wells?
I received a letter from him, but I don't. Again, according to that's why I don't know if that was valid. And my legal team didn't know that was valid. That's why we were challenging this docket originally.
When you received that letter, did you understand the meaning of that letter? The contents of that letter?
No, I did not.
Did you reach out to
My
district staff?
testimony, I reached out to my legal team about it. Yes,
Did you talk with district staff after you received that letter?
I did not.
So you're saying that Mr. Dooling was incorrect when he said that he did speak with you on several occasions?
Mr. Dooling is incorrect that we never had a conversation with that, about that.
All right. If we could turn to the compliance agreements, the settlement agreements, Mr. Schlatters got me saying it now. If we could turn to,
These.
Mr. Frieden, I did not ask you a question. Mr. Myers, if we could turn to the settlement agreement, please, page 5. About the, let's see, 4th line down. Does it say any subject well that is denied temporary abandonment status by staff shall be brought into compliance with K.A.R. 823111 by either return to service or plugging in accordance with this agreement? Did I read that correctly? Mr. Fried, did I read that correctly?
These wells had an active TA status.
Mr. Fried, that wasn't my question. Did I read that sentence accurately?
Did you read it accurately?
Yes.
I think so, yeah.
And then the next sentence says, if operator chooses to return a subject well to service or obtain approved TA status, operator shall conduct a staff witness casing integrity test at the well prior to the well or wells being brought into compliance. Did I read that correctly?
Staff and these wells were MIT'd and you guys allowed us to not do that.
Again, Mr. Frieden, that was my question. I was just simply asking if I read that correctly.
Yes.
Thank you. So my question, Mr. Frieden, is where in this settlement agreement does it say that simply by conducting a CIT, a well is automatically TA'd?
Conducting a TA, we did those TAs or CITs when our license was suspended to bring all of our wells into compliance. That's when that TA was, or when those CIT tests were done.
But did you get approved TA status for the wells?
We were working towards that when our license was, when the commission ruled in our favor and we were back on the compliance track. So we worked, so that's why we stopped with the CITs.
So am I understanding from that that's a no, that you did not get TA status?
Actually, we were working, we still are, we're putting all those wells back into production. A lot of them.
Have they been put into production by the state?
Actually, the Mullen wells, is that what which wells are you specifically talking about?
Yeah, let's talk about the Mullen wells. Have they been brought back into production?
Actually, there are, yes, don't hold me to, yes, those wells all have pumped, yes, I can verify that, but yes, there are pump jacks on those wells and my team, I think has put those wells back into production.
And when did they do that?
Over the last month, or no, from January, let's just say over the last month.
So sometime in February is when you're saying?
Possibly, yeah. We have been working to bring as many of those past CIT wells back into production. Our goal is always has been to work with you guys to do all this. I mean, that's why we worked feverishly when our license was suspended. Our only way to get our license back at that time was to do those CITs to bring all those wells back into production. So
if I'm understanding correctly, you're saying that you brought the Gay Mullen wells into production in February?
Again, I do know that there's pump jacks on those wells.
Okay, so when you testified,
putting them back into production.
So when you testified earlier that those wells were in production in December, was that a mistake?
No, the well that your staff was out there working with us, Brad, and you can confirm with him, he was out there multiple times before the deadline because you had communicated to us before the deadline. So we were working with him and he's fully aware of that. We were working in cooperation to really to meet. I mean, every day we were working to avoid these legal consequences, these constant problems to avoid this. So yes, we were working on, and again, I think there was a switch out there on a well, and Brad was fully aware of that. So
just to understand.
Predated that.
So are you saying now that the Gale Mullen wells were in production in December? Is that what you're saying now?
No.
Okay, so they weren't in production in December. So they came into production after December 31st, 2022. Is that correct?
I'd like to lodge an objection to the reframing of Mr. Frieden's testimony. I believe he testified those wells were compliant. I don't think he said they were producing, and they're injection wells. We went through that for 10 minutes. So I think to say that they were producing is a misstatement of his testimony.
The Gale Mullen wells are
Correct.
producing wells. They're not injection wells.
The Gale Mullen wells,
Correct.
Yeah, the Thornton wells are
they
the
were
injection wells.
compliant.
We
Now you're saying
submitted
they're
6
producing.
wells. We submitted 6 wells and 1 for extra. And on the Mullen, there were 3 wells out there that passed CITs. And Brad, you can confirm there was a problem. We were working to get one of those on. And whether I submitted in the email, we were going to count one of those. And Brad, we had to make a switch because there was they all passed CIT. So it was a matter of bringing one of those wells on to count. And I don't know what the number was. I wasn't there, but your staff person worked with us. There was motor out there. It was equipped and it was pumping. So that's all it was in my testimony. I don't know what number it was, but your staff member can verify that. And
Okay,
Brad Boehner.
Okay, so one of the Gale Mullen wells was pumping in December?
One of the Gale Mullen plus the 4 injectors, which I am still maintaining to this date, were compliant. They passed MITs and they were compliant. I didn't say they were taking water. I said they were compliant, and you didn't mention that, and there were no issue. The only issue you mentioned in your email back to us was the Mullen. The 2 Mullen wells I submitted, and so we got one back in to production, and Brad, your person, gave us confirmation on that, who was out there 4 or 5 times with us before the deadline. And the only feedback we got was after the deadline. So how could we address a problem after the deadline?
Sorry, I'm just looking through your testimony real fast.
And yes, there's confusion on well numbers. I know that they made a change out there, and Brad was fully aware of that because there was a problem with some downhole. I mean, it passed the CIT, but he allowed the switch. And so there might be some number changes in the email, but the bottom line was, again, we're talking about compliance deadlines. They all passed CITs, and it was before the deadline. So it was a
Mr.
number.
Frieden,
Yes.
do you think it's an operator's duty to know the numbers of their wells?
Yes, I know the wells that were past CIT, but we were under a deadline there, and they were doing that during that day, and they were communicating. And again, I submitted 6 wells, 2 Mullen wells. So we used 1. And Brad is fully aware of that.
And so these are the Mullen wells that we just went through that had no motors or were completely.
One of those wells was
one of those wells. Right. So one of the Gale Mullen wells. And let me bring up. Testing.
Plus, we had, as we've talked, well, anyway, that's anyway. Because we worked very hard, and staff was very supportive of us and worked with us. And I don't know on the 3rd, 3 days after the deadline, and that's why you got back to us. We, our counsel, thankfully you let us know if there were any issues that we could address ahead of time to avoid all this. And the only 2 wells that we were told that were problems were in the Thornton wells. You didn't mention anything until the 3rd. So how can we address any problems? I mean, shouldn't there have been well, anyway, I'm not going to get.
So, Mr. Frieden, my understanding is that the staff considers the Gale Mullen E43 well, an oil producing well, to have been returned to service. Is that the well you were talking about?
It's again, I'd have to, it was one of the wells that I submitted to you. Again, I'd have to confirm that with my staff. I wasn't there. And they're all lined up together, and I know they made a switch at the last minute with staff approval.
So with the 5 other wells that were deemed to be in compliance for the first quarterly deadline, plus the Gale Mullen E43, that's only 6 wells that were in compliance by December 31st, 2022. If you are saying that the other Gale Mullen wells were not producing, am I understanding that correctly?
I submitted, and again, my email notification was just a formality. It just says in the document, your staff was in full contact, worked with us. We had already, I mean, the email was just a formality, as in it just says, I wanted to make sure that you had that information. So, you know, but whatever we submitted was just letting you know that these, and I put in an extra well to, you know, just for compliance sake. And we had also, again, we had worked for during when our license suspension, we had, and again, I would think that you would allow that since we checked, I don't know the exact, I mean, it's in my testimony, but went through and we had scheduled actually all the wells to be CIT'd. And I would think that, you know, that would be more than enough to more than meet the requirements and show a very good faith effort to, I mean, the significant effort we made to actually meet all the well compliance. I didn't think we'd have a problem. So
you scheduled the CITs, you didn't do the CITs, is that correct?
we scheduled the CITs until the ruling came down from the commission that got our license down, but the ruling was favorable to us. We were going to literally comply. We were literally on task to CIT all the wells, to plug any, I mean, we were fully, we didn't anticipate a ruling, and we were, the only way to get our license back, according to at that time, was to CIT all the wells, to bring them online, or to plug the few that we needed to. That was, we were going full steam until that ruling. That's the only way that we felt, and we worked, as it says in my testimony, we worked incredibly hard, and staff was with us, and we worked with them, and they were very supportive of us, and we have a very good relationship with your field staff.
Mr. Frieden, when was Ace Energy's license last unsuspended?
It was the ruling came down, I think it was November. So
Does November 21st, 2022 sound correct?
Yeah, so during the time of suspension, that's when we worked feverishly, and we also plugged a well, and we just worked so hard to CIT, to test, and yes, we were scheduling to test all of them.
So am I understanding correctly that having a suspended license made you work feverishly?
We had no choice. We went down two paths: to challenge the ruling, and the commission ruled in our favor, and we, and that's what got us unsuspended. Otherwise, we had no choice otherwise we're out of business.
So having a suspended license did make you work more quickly to bring wells on the settlement agreement into compliance?
We had no choice, and the commission ruled against, ruled in our favor, thankfully, and we were able to, unfortunately, at a huge cost to us, litigation and an unfortunate month that should have been avoided, but we had no choice. In order to get our license, we had no recourse except to fight.
And since your license has been unsuspended since November 21st, 2022, how many CITs have you done?
We have actually worked to bring all those wells and more back into compliance, production status.
But how many CITs have you done?
We haven't done any because we're bringing wells into back into production.
So would it be fair to say that having a suspended license led you to be more proactive in doing CITs than having an unsuspended license?
No, it has no bearing. We feel just like the first time, we feel that this docket this challenge is for lack of illegal, and we are going on with our business and trying to continue to just knock all, to make our case, which I think we're doing today. So
Okay, no further questions at this time. Thank you.
Thank you, Mr. Kimbrell. I'll turn to commissioners for questions, and I'll start with Commissioner Keen.
Thank you. Good afternoon, Mr. Fried.
hey, thank you, sir.
A few overview questions for me. Help me out here. How long have you been engaged in the oil business?
Little over 10 years.
All of that with ACE?
Yes.
Okay. You sell gas as well or just oil?
I do not sell gas. No.
Okay. What was your experience prior to coming into this business?
I'm a serial entrepreneur, and I've run a large family business and done various other businesses along the way.
Okay. So you've been in the oil business for roughly 10 years, if I understand you.
10
Right.
years, and I had previous oil education. I mean, some self-education. Yeah.
What was that about? How did that happen?
Prior to getting into business, I spent a lot of time analyzing all aspects of it before I made the decision to get in.
Okay. Are you the sole owner of ACE Energy?
Correct.
Okay. What's the extent of your oil field experience?
Actually, quite extensive. I'm not on the ground every day, but I'm a hands-on owner. I drill. I've been involved in all aspects of the operation. I'm not just a investor that's, that is unaware. I actually have a geological background. I'm self-taught, but I know a lot about many various aspects, obviously through experience, through making mistakes, through learning things, through being around a lot of people. But because I run a small organization, I have a lot of experience, and I handle. I work with my team directly, and it's my full-time effort.
Okay. So you're not a passive investor. You're actively involved.
No, I'm an active operator. This is my full-time job. It has been for years now.
Okay. So I take it that and certainly given the length of time you've been doing this, you're pretty familiar with the different types of oil field equipment and oil field terminology as well, are you not?
Absolutely.
How many wells, how long has ACE Energy been in existence, roughly?
ACE Energy, a couple years prior to maybe 2 years prior to my Kansas operator's license, but I think the operator's license, I think it was 13.
Okay. Are all of the wells you operate located in Kansas?
Yes.
And how many wells in Kansas does ACE Energy operate?
I operate just shy of, I think it's just shy of 500 wells.
Wow. Okay.
A lot of wells.
Oh, all Eastern Kansas.
Hold on. I zoom here. Yes, sorry.
All in Eastern Kansas. I didn't mean to talk.
I'm in 7 counties. So yes, I have a lot of responsibility. I take pride in that, and we've worked very hard with, and we've had a wonderful relationship with our field staff over the years. And personally, I've gotten to know a lot of them. Yeah.
It appears from the photographs that are part of the evidence the staff has introduced, it appears to me that all the wells I see in these photographs are slim holes. Is that correct?
Yeah, those leases are in Crawford County, and they are 220-foot slim hole, 2 7/8 casing. And your previous question of their Schedule 2 completion, they're open hole. They're not that old. The Mullen lease, we put in all brand new. I completely redid the infrastructure on that lease about 3 years ago.
Okay. Are all of your wells slim holes?
About 90%, even more maybe.
Okay.
All scheduled to, or I can't think of it. I don't even have a well that's the one completion that he was talking about. They're all, I mean, I have more wells than just about anyone, and I know just about every single one. I mean, I am all over the inventory, and yes, they're anyway. So
it sounds like with the hands-on approach that you take, are you familiar with the leases and the wells you own or operate and the general surface topography of the various leased lands you have?
yes, I handle personally now, and I can explain the issue about the date, but
We'll get to that.
yeah, I know I handle compliance myself personally. I don't outsource it to other people. I do KCC compliance. I have to with this number of wells. I have to do that. I know regs in and out probably better than most people, most operators. So I will say that.
Well, the reason I asked about the topography was because as Mr. Kimbrell went through and showed you photographs of the various wells, there were 5 of them there that I think he focused on that were referenced in your email back to the state. When he was asking you to identify if each one of those was the well he was naming as being the well, and you seem to be hesitant about that, even though there was certain objects and relief in the background that would kind of show you the relative positioning of where those wells are. That's why I asked you if you were familiar with the topography of those leases.
Yeah, I have 500 wells in my inventory, and those specific Mullen wells, like I actually do know, because I have maps. I mean, I'm all over, and but those specific Mullen wells are right next to each other, and we are in the process. I mean, some of my wells, even on this, I mean, the numbers have changed. I mean, that's why I go off of APIs almost, the last 4 digits. We have wells that, I mean, Russell years, I mean, we've had issues with wells that have the same numbers that have changed. There's 2 R90s. I mean, even on this docket, but those wells are 15 feet apart. I know exactly where they are, but you know, when I in my head are this, are that, I know most of them. But in that specific case, when we were talking about, and we made a decision at the last minute to switch wells, it was not about not knowing. It was a matter of knowing which one that we were going to apply to the settlement agreement. And I didn't think it even mattered because staff was there and they knew. The email, whether I sent in an email or not, it was really, even if I didn't send an email, I just wanted to legally comply with the language because staff was fully aware of what we were doing out there. Brad had come out 3 or 4 times that same day to work with us.
of the 500 wells roughly that you have in your inventory, have you drilled all of those yourself, or have you acquired
Oh, no.
existing production?
Yeah, those were, I've, on the Mullen, actually, I've drilled, I redid that lease and I drilled probably 5 or 6 of those wells, but that lease was completely redone, hence the dual completion and I mean, the injection and, you know, having it dually, it was plumbed for injection for later purposes. And there is power run to there. And that's why those guys don't even know that, because they weren't there. But what was your, I'm sorry, what was the question?
No, I think you've answered.
Okay.
Let's turn to the question that Mr. Slayer referenced when he proffered you for cross-examination. I want to drill down on that, so I'll fulfill his wish there. Having to do with the issue of the discrepancies in the date where TA well applications were shut in, the date of shut in, and there's discrepancies in those dates. Could you care to explain? Can you help?
Oh, yeah.
We had just to kind of paraphrase what I understand the circumstance to be. We had several applications where there was a shut-in date of 2010, and then some 10 years later, there was a subsequent application for TA status on the same well that showed a more recent shut-in date, something other than 2010. So help us out. Help explain the discrepancy for the benefit of the commission, if you would, please.
Oh, I can very clearly, and I wish staff had asked me this years ago, or, you know, and again, staff has never had a problem with this before, but I'll give you the real explanation, and it makes a lot of sense. I acquired these leases it was a package, that McCune package, the Mullen, the Underwood 31, the SAMP, all those leases there, they're all connected. I acquired them in the exact date, I think, because I wrote it down this morning, was, as I went back to the T1s, was 2/2/15 of 2000, so February 15th of 2015. So at that time, I had a gentleman working for me named Peter Jeffries. He submitted the T1s. He was handling the paperwork, and at that time, Kohler wasn't up and running. It was all hand done. And unfortunately, when you hire people, and this is why I eventually took over my own operation, because I couldn't trust anyone to do it. But he put on, he was handling all the TAs. He had no idea what he was doing. And again, I didn't even own the lease in 2010. He just put on all those dates, and he was pencil whipping. He pencil whipped a whole bunch of stuff, just making stuff up. And I didn't even operate the lease in 2010. How did he even know? And I didn't catch it. I mean, for years, and just like you said, or Troy, so much information. When you have 500 wells, I mean, the GPSs have been wrong in case all this stuff with Kohler, bringing it all online has been wonderful. But the information on all these TAs and the T1s, it's all wrong. The casing, everything. And I've made a diligent effort every year to update this information. And the pure information is it was an error on, I guess I'm responsible initially, but it kept being repeated. And that's why these dockets, when they were filed, I wish they gave us a chance to work with us to give this explanation that it was an initial paperwork error that makes total sense, because I didn't even own the lease in 2010. So the talking to my staff recently, when this came up, we went back and we always, every year when TAs come up, or when, you know, GPS, we're constantly trying to, I mean, even now, they were out there dueling, and his staff were GPSing well locations. Well, how come that wasn't, I mean, that's a mistake too. We all make mistakes. And when I submit TAs, it says to the best of my knowledge, and I have to rely on field information, because yes, I'm not out there every single day. I know a lot. I know that I have 500 wells, and on a lease, I've operated all these leases. Most of these wells have been produced. I can guarantee you it was produced after 2000. I mean, 2010 is years before so yes, that date is completely accurate. Did I falsely put that in there? No. But to the best of my knowledge, so if I acquired it on 2010, I'm well within the 10-year date, even today. Or acquired it on 2014. So to the best of my knowledge, some of those wells are even equipped and are probably active or could be active, but I was never given the chance. These were thrown on a docket, and I was penalized, and that's why I was fighting all these. This entire docket is based on all these 45 wells. They're all based on the 10-year TA, and I was never given a chance, it's in my testimony, to bring this exact conversation up. And it makes very clear sense to me. Maybe I'm misguided, but unfortunately I had hired a person, and that's why I handle all the paperwork now. And based on our research, to the best of our knowledge, and like, we're bringing on most of my wells and back into production. So these are all wells that are TA'd, have been TA'd for years, since I've owned them, and they're all under 10 years. They don't pose any threat to the environment. They're all slim hole. I take care of my leases, and this whole experience has been, as I said has been horrible. So we work so hard every day, and it's just been very difficult. So it's a long answer, but does that make sense?
Well, let me follow up. So for a given well, we'll have one document that shows a TA date of 2010. And for the same well, we have another TA filing that shows a completely initial shut-in date. And yet on both of those documents, you executed both of those forms, did you not?
Yes. Or no, I'm sorry. No, I did not. No, I did not. They were, I updated the 2018 and possibly mistakenly updated for the last I did not do the initial few years of the TAs.
Do you review the information on these forms before you execute them and file them?
Do I review them?
Correct.
Yes, but to the best of my knowledge, yes. And that's why I caught the error recently. Yes.
Okay. There's one thing I'm curious about, because
but it doesn't make sense to have a 10-year to 2010. I'm always correcting stuff, and it says to the best of my, I correct like the casing information, that's why it says edit and resubmit. And usually for the past, they find errors, I resubmit it. That's been always the case, always for years up until this situation. The staff has been wonderful to us, oh, this is wrong, and they send it back to us for correction, and we correct it. I've never had this experience before in 10 years, up until this docket in the last year or so. That's why there's an edit and a resubmit.
Change subjects a little bit here. I want to go back to the matter was brought up. I can't remember now. It's becoming a long day. It was, I think, in conjunction with the testimony, either through Cross or in some other fashion, of Mr. Dooling. I think that, or it could have been something Mr. Slatter indicated. I'm not sure. I'm not trying to be unfair to anybody here, but I'm going to ask you the question rather directly. Given your experience on slim holes, have you actually tried to inject water into and produce oil from the same well at the same time?
No.
Okay. Somehow I picked up that had occurred, and I was, that would.
No, that
would be difficult for me to
understand. No, and again, when he said it was plumbed, if I was injecting water, don't you think he would call me and I'd have an immediate violation? That's a serious issue. And again, I rebuilt that lease, put in injection for the future to permit those for future injection, and those were TA'd, and those were, so it doesn't make any sense. So does that explanation make sense?
Two more questions for you, Mr. Frieden, if I might.
Yes,
In
please.
fairness to you, I'm going to ask the same question of you that I asked of both of the state witnesses, because I want to give you a fair chance to have your take on it as well.
Okay.
In your opinion, under settlement agreements, or this is a settlement agreement, you don't care about a compliance
Mhm.
agreement, you're concerned with the
Yeah.
settlement. Under settlement agreements between operators and the KCC staff, which of those parties do you believe has the obligation or burden to comply by taking affirmative steps that are set out in those agreements? The operator or the staff?
I voluntarily came to staff and voluntarily entered this agreement to save litigation. I didn't have to. I was the burden to.
I understand all that. We don't need to go down that trail anymore. The question is very specific.
Okay.
It is under these settlement agreements, which of the parties, the staff or the operator, bears the burden to comply with the affirmative steps that are set out and required by the settlement agreement?
To comply, well, obviously the operator needs to is responsible for the wells. The operator is responsible, but I feel staff needs to be honest and follow the rules as well and interpret the laws, and it's working together and working together to make sure wells are compliant. It's a partnership.
Okay.
But it starts with the operator. It starts with making sure that my 500 wells are safe, and that, because I can't make money, I can't protect I don't want any problems. I have a great responsibility, and staff has other things to do. I prefer them to go and do other things. So does that answer your question?
One more question. John Myers, if you would bring up the page number 5 of the settlement agreement, please.
Yes, one moment.
And kind of center that a little, if you would, John. Giving us some practice on that page, aren't we?
What would you like to see on this page, Commissioner Keen?
Well, we don't have the benefit, as I indicated, I think, to Mr. Russell. You can leave it right there. That's fine.
Okay.
This is page 5. It's subparagraph H, Mr. Frieden, of the terms of the settlement agreement. And within the settlement agreement, if you would bear with me, go down about from what's on the screen. Can you see what's on the screen there, Mr. Frieden?
Yeah, I can see it. Yeah.
Okay, go down about halfway with what's on the screen over to where Mr. Myers has marked it over there, where it begins. That sentence begins with the word failure. You see that?
Failure at a time. Okay. Yeah.
Yeah. Let me read that sentence once again for the record. I want to give you the benefit of having a chance to respond to this in the same fashion as I have for previous witnesses. It says failure to timely bring the subject wells into compliance by the appropriate deadlines or to pay the penalties by the appropriate deadlines shall result in suspension of operator's license. Within the context of your wells, and this is your compliance agreement, what does that sentence mean to you?
This sentence means to me that if I did not meet, if my wells that were part of this agreement that I entered did not meet per the appropriate deadline, that the wells, I would bring in those wells to meet the per the deadline, that the license would be suspended per that deadline. Not all the wells. Not to bring in all the wells for the compliance agreement.
What is it about that sentence that would indicate it's not all the wells?
It says timely bring into compliance by appropriate deadlines.
So bring the subject wells into compliance.
Subject wells. So the subject wells are the 5 wells that were per that specific, and that's what I've read in other agreements as well. So I think it's an extremely harsh penalty to, especially when there's disagreements. It doesn't make any sense to me why, yeah, I don't see any interpretation on that. Yeah.
So it's your opinion that subject wells does not refer to all the wells subject to the compliance to the settlement agreement.
Correct. Subject wells, because the previous sentence before is 5 wells. So the subject wells is 5 wells. Yeah. There, it doesn't say all.
All right. Mr. Frieden, that concludes all of my questions. Thank you very much. I'm no further questions for this witness. Thank you.
Thank you, Commissioner Keen. I'll turn to Commissioner French.
No questions. Thank you.
Okay. Good afternoon, Mr. Frieden.
Afternoon, ma'am. Your Honor.
So I learned that you have about 500 wells, and I think you stated that you felt that suspension of the license was a very harsh measure to have imposed upon you, and can you tell me why then?
Well, considering that my wells, and again, in my testimony, were on day one, the reason I entered into this agreement was I knew that they would pass TA, and they did pass TA as submitted. That I knew that they were not 10-year out of compliance, and this entire process has been harsh, and an entire suspension based on, and this has happened now twice, and the fact that we had a previous commission ruling that that we needed to work together, and now this is the second time that we're being brought before the commission. I just can't understand that why this is 10-year. It's just, I don't know. Am I answering your question, or maybe
Yeah, that's fine. Let me ask you, you keep referring to your people, your staff. Who do you employ on the ground to do your work? And who else do you employ to maybe do the paperwork? Or maybe they're the same. I don't know.
Well, yeah, and that's another thing, is that I have a very slim staff, and and again, we are managing to take care of everything. But when I've had to spend that entire month, when we're shut down and we're so focused on this, it takes resources away from managing my operation, and the amount of money and time, huge amounts of money, huge, and time and wasted effort to focus on TAs and tenure. It's just awful. And I don't have that many people. I have contractors. I have maybe 5 people that handle everything. I have my own equipment. I do rely on some outside contractors, but I had to plug a well during this same time period, and I asked for an extension. And actually, they wouldn't even let me plug it. Because my license didn't have plugging, so I had to go outside to find a plugger, which was very difficult. I had a 5-day deadline. So, during my license suspension period, and again, I'm just saying, it was very difficult for me to maintain 500 wells in 7 counties. I normally can do it. I'm fine when when my license is up and running, but it's been very hard under that, when a license is suspended like that. And then to focus on, the only way to get my license back is to focus full time on bringing 40 or whatever it was, all those wells to do CITs. And then, we were told at the time that we'd have to bring those wells into production or plug them. And there wasn't, we were told at that time, there wasn't a TA option. So it was a burden on, it's in my testimony, but it was a burden on us. And
So, let me just ask, were you a signator to the settlement agreement personally, or,
on behalf of Ace Energy, and we negotiated 4 months on this and again, I voluntarily, because we were prepared to fight this because we disagreed with it. It wasn't something that I was fully prepared to, because it was all about 10 years when the issue here. And I just felt, the TAs will all pass, I'll pay the fine and we'll move on, which was the case as of January, I paid the fine and most of the TAs passed. But unfortunately, it's turned into a nightmare for us. And unfortunately, for the commission and for staff, it's been a huge time suck and expense and cost all of us for an issue. You'd think that I've polluted Kansas and caused the Keystone spill. But I'm sorry, what was the, I'm sorry.
That's okay. Let me think here and look at my notes. Hold on.
That was in my testimony. And again, I'm just being honest. But yeah, we worked on the settlement agreement for 4 months and back and forth. And David, I don't know if he's still on, my counsel worked on it back and forth and back and forth and back and forth. And it just was very challenging. It started in February and it wasn't solidified until May.
So
and we approached the KCC with the idea because we were prepared to continue litigation.
okay. So you approached KCC with the idea.
Yes.
But it took that long to negotiate one, and you and your attorney finally agreed to the negotiated settlement agreement, correct?
Correct. We had challenges negotiating with, I mean, again, he can speak to that. So.
Okay. All right. Okay. I believe that's all the questions I have for you, Mr. Frieden. And so I'll turn back to Mr. Schlatter.
I don't believe any redirect is necessary.
Okay. Mr. Kimbrell.
Just very briefly. So Mr. Myers, if we could pull up exhibit RD1, page 2 of 2. Yeah, perfect. So on paragraph 4, Mr. Frieden, that's the oil wells that were currently plumbed for injection purposes that were revoked TAs. And am I correct in reading that those wells are the Gale Mullen C43, Gale Mullen I43, Underwood 6, R90?
That's his letter. Yeah, that's what he's claiming. Yeah, plumbed.
Okay. And if I remember your testimony correctly, you said that that's a serious issue, and you don't understand why staff didn't reach out to you regarding that issue.
No, I said if they were injecting illegally, I don't even know if Underwood 6 wasn't even injecting. It has no injection. So no, I said if I was injecting, he should have reached out to me. He did not.
Okay. Mr. Mars, would it be possible to pull up penalty order docket number 23 CONS 3087?
Excuse me, what part of the direct exam would this be cross-examination to?
This is Mr. Frieden's testimony that he wasn't told that he shouldn't be injecting illegally into these wells.
There's no foundation for that in this docket. This is another docket we can talk. Mr. Myers, will you stop that, please? We're outside the scope of direct here, and I think piling on at this point, we've addressed the issue with those 3 wells. If we want to talk about unlicensed injection, unlawful injection, we've got I believe another forum for that. And it's certainly not part of the direct testimony.
Well, I think it's considering Mr. Frieden said that he wasn't contacted about this and that there was no unlawful injection. I think it's reasonable to bring that up during this hearing.
I think
I believe you muted, Chair Duffy.
Gentlemen, we're towards the end of the day, so I think we will, Mr. Kimbrell, if you can, just continue on to your recross, please.
All right, thank you. So Mr. Myers, could we instead pull up the settlement agreement, page 5?
My apologies, the settlement agreement, not this penalty waiver. Yes, one moment. There you go.
If you could scroll down a bit to the sentence where it starts with failure. So, Mr. Frieden, Commissioner Keen talked extensively with you about this sentence. I'd like to read the next sentence where it says, operator agrees and understands that if its license is suspended for the failure to meet the deadlines above, the license shall remain suspended until all of the subject wells have been brought to compliance with K.A.R. 82.3.111. Did I read that correctly?
You read that correctly.
And after reading that sentence, does that change your understanding of what happens to Ace Energy's license if it is suspended under this settlement agreement?
No. He didn't ask me that, so.
No, I'm asking you, after reading this sentence where it says that all wells that license shall remain suspended until all the subject wells have been brought into compliance.
Not according to what my legal team has advised me.
Okay, thank you. No further questions.
Okay, I'll go back to commissioners. Commissioners, do you have questions? Okay, very good. Mr. Frieden, you can virtually step down, please. Thank you.
Thank you.
Okay, we're going to move to closing statements, and we'll start with Mr. Schlatter, please.
Seconds.
And you are muted. There you go.
I am.
Now you're okay.
Okay. I didn't have much time to prepare much here on this, but I'd like to revisit. I guess you say you're closing back and you're opening back and closing, or what's the old adage? But again, the posture of this case is staff's motion to suspend his license. In order to carry the burden that the license should be suspended, staff had to establish that 5 wells haven't been brought into compliance, or I guess 10 wells at this point. 10 cumulative wells haven't been brought into compliance. I sat down with Mr. Dooling and went through about 15, and that doesn't count the 20 that were revoked or unapproved. There are 12 TA applications pending staff's approval that he indicated could be approved. Whether or not those will be approved is to be determined, but I think if they are, and they should be, then I believe operator is compliant and staff hasn't carried its burden. As to the 20 wells that were unapproved for 10-year TA status, no testimony was presented or anything that resembled direct evidence that those were properly denied for 10-year TA status. Indeed, both witnesses testified they had no actual foundation for their position other than looking at an old document that Mr. Friedman's now explained why all those wells were 12/1/2010 and now why they have specific dates. To me, that the latter makes more sense. Again, not Mr. Frieden's burden, staff's burden. The last thing I'd like to note is we've spent a lot of time in this agreement, and it seems like staff is advocating for an extremely narrow interpretation of the words in those agreements. Basically, that the quarterly compliance objectives aren't relevant in the interpretation of the agreement, only that the all wells have to be brought into compliance immediately whenever they decide there's non-compliance. So that's unilaterally their call. And then now we have this draconian obligation on a negotiated settlement agreement that did allow for 5 wells per quarter. Every other docket I've been involved in has allowed for the operator to catch up, if you will. I think we've got real questions as to which wells are compliant and which are not. And that's not what this particular forum is for. We heard testimony about 4 wells. One, staff spent forever on this Gale Mullen 43 well. There are 3 wells called the Gale Mullen 43, and in staff's own testimony, it acknowledges that one of those 43 wells is compliant. I don't know why we spent time on that. As to the Thornton wells, they've been approved for TA. Now they're not approved for TA. Now they have to be injecting. Now they have to be this, that, and the other. And it just seems like a never-ending spiraling series of compliance objectives. And there's no clear answer as to which wells are compliant, which wells aren't. Mr. Frieden, through his testimony and through cross-examination, put on a case that 42 of these wells are compliant, which would put him way far ahead of where he needs to be as of today. If perfunctory action can be taken on the pending TA applications, we're caught up and through the end of the 3rd quarter of this year. I think there's plenty of opportunity or plenty of room to show that he is indeed compliant. There's not sufficient evidence to show that he's not. And for that reason, this procedural motion should be denied, and he should be allowed to continue to operate his wells and continue to fulfill his obligations under the compliance agreement.
Thank you, Mr. Slatter. Mr. Kimbrell, your closing statement, please.
Thank you. Commissioners, in my opening statement, I said this docket was all about counting to 10. I predicted that Ace Energy's counsel and Mr. Frieden's testimony would try to make it as difficult as possible to count to 10. And I think they've tried to do that. But the simple fact remains that the settlement agreement required Ace Energy to bring 10 wells into compliance by December 31st, 2022. Not in February, not in March of this year, not pending approval by staff, by December 31st, 2022. As of today, only 6 wells have been brought into compliance. The settlement agreement says that if a deadline is missed, Ace Energy's license will be suspended and shall remain suspended until all the wells in the agreement are brought into compliance. That's the plain language of the settlement agreement. There's no room to try and understand a different meaning for those words. Staff asks that the commission find that Ace Energy missed a deadline in the settlement agreement, that its license should be suspended, and its license should remain suspended until all 45 wells in the agreement are brought into compliance. Thank you.
Thank you, Mr. Kimbrell. Okay. Before we conclude, I want to see if there's any post-hearing issues, including whether the parties would like to file post-hearing briefs. So parties, if you would like to comment, Mr. Schlatter, do you have comments?
Yes, and as I believe I've communicated to this commission before that I dislike filing briefs of all kinds. But there seems to be some confusion as to the interpretation of this agreement, whether what staff's extremely narrow ruling for Mr. Frieden is one argument. Well, while they have broad discretion to amend the agreement, to revoke, unrevoke, do whatever they want as far as the wells brought into compliance, I think we might actually need briefing on the interpretation of that agreement, unfortunately.
Mr. Kimbrell, do you have thoughts on that?
I would be happy to do a brief, but I feel like these issues have been fully aired during this hearing. I'm not sure that there's anything we could add that the commission hasn't already heard.
I mean, the interpretation of a contract is a legal matter. It's not for evidence.
Sure, and I think that the commission has heard exactly what the different understandings of that contract are.
Okay, I look to allow this specifically on this subject, but I'm going to give you just 2 weeks, okay? And so I turn to the commissioners. Do you have any other issues that you would like to raise? Commissioner Keen, Commissioner French? Okay, I'm looking around the room. This concludes our hearing on this docket. At this time, I close the record and adjourn. And I appreciate all of you participating in the hearing, and have a good weekend. Thank you. We are adjourned.
Mr. Schlatter, Mr. Kimbrell, if you could stay on for a moment, we will not be live streaming in a moment. And we'll have another matter. It would be useful, I think, for us to discuss.
Thank you.
Unrelated to this docket.
Thank you, John.
Yeah, thank you. All right, IT department.